Good afternoon, ladies and gentlemen. This is the code enforcement meeting. Will now start. The time is now 6 p.m. Okay, has everyone gone over the minutes? Okay. Do I have a motion to approve the minutes as is?
Do we want to do a roll call?
Oh,
first?
okay. Sorry. Today we have present Falcone, Fanolis, and we also have, you can introduce yourself, gentlemen.
Evan Fracasso.
And,
Sue Makowski.
okay,
Sylvester.
Sylvester. We now have a quorum of 5. At this moment, we'll have a pledge of allegiance and a moment of silence. I
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, ladies and gentlemen. Please be seated. Okay, I got it now. Okay, again, do I have a motion to approve the minutes as they are?
Make a motion to approve the meeting minutes from March 17th.
Do I have a second?
One second.
Okay, we have a second. All in favor?
Aye.
Okay, very good. Now, I'd like to make an open statement. Welcome to the May 19th, 2025 City of Clermont Code Enforcement Board meeting. Before we begin, I would like to advise everyone about the procedures that govern appearances before this board. This meeting is open to the public under Florida government in the Sunshine Law. The Code Enforcement Board is acting in a quasi-judicial capacity when considering individual cases. However, every effort will be made to hear all persons having relevant evidence or argument to offer in accordance with rules for such proceedings. We ask that each person who speaks before the Code Enforcement Board sign the sign-in sheet located on the table up front. After opening remarks, all those who intend to speak today will be sworn in or affirmed. When asked if a respondent is present for your case, please come up to the podium. All proceedings before this board are electronically recorded. Please speak directly into the microphone at the podium and state your name and address clearly for the record. Additionally, please limit your comments to only information relating to the case being presented. The City of Clermont has the burden of proving a violation exists. The city presents their case, and then the respondent presents theirs. Once all cases where respondents are present have been heard, the board will then hear the remaining cases. Each party may question witnesses offered on behalf of the other party. Additionally, the board members and their attorney may question those appearing before the board. This board will then make a decision based upon the evidence and testimony presented by both parties. The board's role is to determine if a violation exists and, if so, in most cases, set a date for the violation to be corrected and set a fine if compliance is not met. It is not the board's role to advise you of a specific method or act that you can take to come into compliance. The Code Enforcement Board is appointed by the City of Clermont to review alleged violations of the City of Clermont Code Enforcement Ordinance fairly and objectively. Its members are volunteers and not employees of the city. The board's authority is limited to determining if a violation of the code exists. If it does not have the authority to change the codes or ordinance. Although you may have evidence, argument, or circumstances that could justify being excused from compliance with the applicable code, you are advised that this board does not have the authority to grant you an excuse. Such an excuse is commonly referred to as a variance or exemption and may be granted through other procedures such as applications to the city, but not by this code enforcement board. To avoid interferences with cases being presented to this board, all cell phones are to be turned off or silenced while in chambers. Okay. Do we have anyone who wishes to speak on behalf of the case?
Madam Chair, would you like me to swear in the
Yes,
city
sir.
folk? Okay. Because these are quasi-judicial hearings, meaning that the formal rules of evidence don't apply, but basic notions of due process must be followed. All testimony by staff and any of the respondents will be taken under oath. So if you're here for a case and are going to testify, or if you're a member of staff, I'll swear you in at this time. If you're able to stand, please do so and raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. Please be seated.
Okay. Do we have our first case?
My name is Avery Dyan. I'm the Assistant City Attorney. I'm just going to go over the agenda that we're going to follow for today's meeting. We'll start with other business, which is item 1, C24040038. That's John and Cindy Zentmeyer, 105 West Magnolia Street. Then we'll move on to unfinished business. That's item 2, C24020018. Elsie and Felicita Rios, 783 East Juanita Street. The next is going to be item 3, C23040040, Pamela Guerra, 873 Sky Ridge Road. Then we'll move on to new business, starting with item 5. That's going to be C25040037. Adveneer at Clermont LLC at 600 River Birch Court. We will then move to item 7. That's going to be C2503-001. That's Kevin Henshaw, 1620 5th Street. Moving on to item 8. That's going to be C2501-0024. Quan Heng and Xing Wang, 240 Edgewood Drive. We will move on to item 9, C2408-0009, Fairfield Homes, Inc., 99 Sunnyside Drive. And our final case will be item 10, C2503-0020, Vet Development, LLC, 7th Street. Almost all of the respondents are present at this time.
Thanks. All right, good evening, Code Enforcement Board. Joshua Cortez for the City of Clermont Code Enforcement. Starting with item 1, C2404-0038, John and Cindy Zentmeyer, 1050 West Magnolia Street. This is a motion to lien. This is a copy of the Code Enforcement Board's previous order. Screenshot from GIS showing the property's location. The notice of hearing for the motion to impose the fine and create a lien sent out by the city's legal department. A picture from the property when the case was first opened. A current picture. The staff recommendation to the Code Enforcement Board is that the property be found in violation, to assess a fine. Actually, excuse me. The staff recommendation for this case is going to be to impose the fine and create a lien in the amount of $32,250 for a property that was in violation for a total of 215 days. I have nothing further if you have any questions for me. And I believe the respondent is here.
When did the property come into compliance?
So the property is not currently in compliance at this time, which is why the city is seeking to impose the fine and create a lien on the property for the amount at the list, the bottom there, $32,250.
Is there someone here to represent this case?
We'll take you over there. Yes, sir. Yep.
Did you sign in, sir?
I have not. I will when we're done. Good evening. My name is Rick McCoy. I'm a professional engineer. Opened up my office here in Clermont in 1987. The Zentmeyers have been friends of mine for decades. Our kids grew up together. They had problems with their balcony, their deck on the front porch, and they had problems getting an engineer to work on it. And John reached out to me, and I looked at it last fall and said, yeah, that's simple, no problem. Unfortunately, I do more land development than I don't mess with I graduated, I majored in structures. The structural part's no problem, but I had no idea before the building code has gotten so complex. Convoluted is a better word. So I've been studying all for like 6 months now, trying to make sure I've got everything covered. You go to one chapter or another. Anyway, I'm here tonight to say it's not John's fault that he has not applied for a building permit, and I just gave him the drawing today, so he's going to go in the morning and apply for a permit, and he'll get that resolved. So don't blame him for my lack of knowledge in the building side of it. I see Kurt over there. Kurt knows mostly what I do is subdivisions and site plans. Done a lot of retaining walls. All my retaining walls for 40 years have still standing. So. My dad always told me,
So
no good deed goes unpunished. He was right here.
I have a question for the staff. Is everything up to date in compliance except for the building permit?
Yeah, so let me just clarify, and I apologize if I wasn't clear from the get-go. The property is not currently in compliance. The fines are still accruing. So basically what staff is asking for at this point is that from the start date that the Code Enforcement Board had ordered the fines to begin, we're asking that they continue to accrue, but at this point we're going to impose the fine and create a lien on the property, and the lien will continue to run until the respondent comes into compliance. So yeah, I apologize if I wasn't clear about that from the onset, but the property is not in compliance at this time.
Okay. Does anybody else have any other questions?
So, from my understanding, then it really is coming down to this porch balcony issue is what we're, the only thing that's not in compliance, based on some of your other conclusions here for your code issues. So that's just,
So currently, the only thing that the city is requiring the respondent to do is obtain a permit for the balcony and for some of the stucco that they removed from the front side of the structure.
okay.
So this comes down to needing 2 permits. That's the only thing, violations that are outstanding at this time.
That is correct.
Okay, very good. Okay.
Could you go back to the photos or the diagrams for me, please?
Okay, so that, the French door is up on the second floor. There should be probably, what, a balcony then, or a railing around the patio?
Yes, sir.
Balcony there and whatnot, and then whatever their front repairs are.
That's correct. Yes, sir. So that would be the initial photo taken. The complaint initially came in as like a bulk refuse complaint from the utility billing department, but upon my initial visit, I noticed there were some other issues, and so they were cited for everything. And currently, the only issues that remain are the issues of the permit for the balcony that should be over the French doors there on the second floor, and then some of the missing cladding from the exterior there underneath the porch.
The question I have is, once the permits are obtained, does the clock stop on the further accumulation of the fine?
Yes, so once the permits are issued, we would stop the fines. At that point, the respondent could potentially come in for a lien reduction through city council. The only thing code enforcement's asking from the respondent is to just simply have the permits be issued.
Okay.
Does anyone wish to make a motion?
Let me just ask one other question, if I could,
Okay.
of staff. So the request of the Code Enforcement Board is, you're asking them to make a motion to place a lien on the property.
Yes, sir, that is correct.
So, for the rest of the board here, my opinion on the matter is, putting a lien on someone's property is a pretty drastic step. You've got the respondent there stating that they're going to have their permits hopefully together in the next 30 to 60 days. How do we feel about maybe continuing this until our next meeting and then addressing it then?
I have one question about that. If we give them extra time, will they still be incurring the fine?
Yes, ma'am.
We need to take that, if you want.
Yeah, I mean, that's kind of, obviously the fine is still going to accrue during this time.
Right.
I just think it's in probably, as all of our neighbors that are sitting here with us.
Okay.
It's a pretty drastic step to go this far for somebody who's actually trying to make an effort.
I concur. Would you like to make a motion to,
Sure. What's the date for our next meeting, Counselor? Thank you.
July 14th.
14th, thank you.
yes. 14th.
14th? Yeah. All right, I'd like to go ahead and make a motion that case number 2404-0038 be continued to the next meeting on July 14th, 2025. This should give the respondent time to get their permits together and be able to move forward with their repairs.
Can I just ask one more question? Sorry.
Yes.
So there's a fine that is accrued of thousands of dollars. We're gonna-
32,000.
Right, we're going to wait 60 days to do this. But if they become in compliance, the city still is going to collect that 32,000, or does that, when they come in compliance, that goes away, or they come in and do a lien reduction or a lien dismissal?
So if the respondent came into compliance prior to the next Code Enforcement Board hearing, the staff would be open to bringing them back for a fine reduction.
Thank you. I just want to be clear.
Okay. Now, may I ask a question?
Sure, there's been a motion, I haven't heard a second.
I'll second that.
All in favor?
Aye.
Aye.
Thank you.
You're welcome.
Okay. Good evening, Code Board members and staff. Evie Wallace with the City of Clermont. This is also a reduction of a fine case. The case number is 2402-0018, LC and Felicita Rios. And it's referenced the property maintenance and nuisances. This was already heard and presented back in March of 2024, but the case did start in, I believe, in January, so it's been close to a year and a half. And these are the orders from last year of 2024. And just some additional information, on March 2024, the initial officer presenting the case, Rabando, presented the case. He's no longer with us, so I took over the case. He had no contact with the owner. I did find the property in compliance on August 30th last year of 2024. No contact still with the owner. We did everything for service by Florida statute. We even posted the property. There is a program that we use outside of our system. It's called Accurate. The police also uses for government, and I did find a separate address, and I attempted that way to mail this one address in Ocala area, I believe. And the owner did contact me that she received the letter. This was in November, and she was unaware of all notices sent. I did explain to her, we posted the property, the service was, clear, required by law. And then she went ahead and made sure that it stayed in compliance. And just to give you a recap, the property maintenance violation was 2 months long. There was a disabled vehicle, which is also part of the violation. So in total, it was out of compliance for 8 months. Fine began in June 2024. It ended in August 30th for a total amount of days of 71. Daily amount of fine that accrued was $150 per day, with a total amount owed today $10,650. Because she kept on making sure the property was in compliance, I went ahead and told her about the reduction. I presented the packet, and she proposed it for amount to be paid of $9,000. This was her input. This is her information, and I did put a little blue arrow showing that that's the amount that she's willing to pay. The location, again, this was presented, but just so you're aware, it's on East Juniata off of Bloxham. Just some of the violations that were presented to show you this property maintenance, disabled vehicle. Okay. And that it was posted, so that's service received. This was last month, just taking a picture to show that, the property has been in compliance. Ms. LC has been in contact with me. And today I took another picture, still in compliance. So I definitely accept and agree to a reduced amount. Again, she put $9,000, and I put in order to be paid within 60 days, just to give her a little bit of time, or the fine will revert back to the original amount of $10,650. And she is here today to talk on her behalf, or her husband.
Good evening, my name is Elsie Valentine, and, I've been disabled for 3 years now.
We understand. Does anyone have any questions?
It was 2 months for the property maintenance. The second violation was 8 months. I'm sorry, the whole violation, the whole property was out of compliance for 8 months. So it was 2 months for the property maintenance and the rest for the disabled vehicle. Again, when she saw got the letter from myself, she contacted me right away, and it's been in compliance since. Again, I'm not object for a lesser amount if that's what you're looking at. I didn't change what she put based on all the on-site inspections I did, the previous code officer did. I believe there was a tenant that was living there. We attempted to see maybe they could contact her prior to her receiving my letter.
The disabled vehicle's been removed?
Yes, the disabled vehicle, we cannot see it from the road, from the street. So right now, the property is in compliance, correct.
I understand you're willing to pay $9,000. Would the board consider cutting that in half?
I would.
What is staff's normal recommendation? We do what, 10, 20%?
Sometimes between 10, 20, it goes up to 50, depending on, it's case by case,
Yeah.
the severity of violations, if there's been any contact with the owner, so I'm not objected at all for, if that's what you all agree to.
Okay. Can I get a motion?
Evie, one question. Have they been very responsive to you?
Since the letter, yes. And she's aware now she has to change her address on the property appraiser, the property record, so that way if other municipalities need to get a hold of her, at least now, they can.
Well, I make a motion in regards to case number C2402-0018. The City of Clermont versus Rios Felicia, that the fine, recommended fine of $9,000 be reduced by 20%. To be paid for by our next meeting date, July 14th.
Do I get a second?
Are you looking for 20% of the original fine, or are we just?
20% of the 9,000 proposed reduced fine amount to be paid. That's here at the,
Well, that's her request amount.
yes.
Okay.
So, I'm not good at math, that's why I went to law school. So are you asking for the fine to be reduced to $7,200 or 20% of 9,000?
20% of 9,000,
Correct.
which should be,
So it sounds like it's $1,800? Okay.
yeah.
I'll second that motion.
All in favor?
Aye.
And that's within 60 days, just to confirm?
Yes.
Yes.
Thank you.
You're welcome. That would be under Order 5.
I don't think I got that one.
Joshua Cortez for the City of Clermont. This is a reduction of fine in case number C2304-0040873 Sky Ridge Road. This is a screenshot from GIS showing the property's location. the Code Enforcement Board's previous order in this case. This is the Code Enforcement Fine Reduction Request Form that was filled out by the respondent. The respondent listed a proposed reduced fine to be $0. This is a picture of the property from Google Street View. This case was pertaining to tree removal, a complaint that the city had received from the HOA. This was the property upon my visit after receiving the complaint from the HOA. A picture taken as of the 2nd. The property is now in compliance. This is kind of a case summary here. Again, it was received by a complaint from the HOA. A courtesy notice was sent out on May 2nd, 2023, followed by a violation notice on the 30th of May. The Code Enforcement Board hearing was held on September 18th. The Code Board had ordered the fines to begin in December of 2023. A lien notice was sent out on April 2nd, 2025, and the property came into compliance on May 1st. The total days the property was in violation was 745. The total fine amount owed is $73,050, and the staff recommendation is to reduce it down to just under 20%, which is $14,500, to be paid within 90 days, or the fine will revert back to the original amount owed. I have nothing further, and I believe the respondent is here.
So this has been a process for us. When we initially received the notice that we were out of compliance, I believe it was just about a week later, and the city of Tiberias was doing their Arbor Day thing, so we thought, okay, well, this would be an opportunity for us to get back in compliance, get the trees back in the ground. They were removed due to some foundational things. The oak tree roots got like that big and were busting up the driveway, and I had to redo all the irrigation. I'm a truck driver, I'm rarely home. But I was trying to get this done, so we went. I wasn't aware that there was an actual height requirement, so when we did call Mr. Cortez back to come and take a look, it was kind of like, we had like 4 trees we planted, but they were nowhere near where they needed to be. So time had passed. We welcomed 2 children in the world since then, since 2023. So things have been busy. We've had 5 kids. My mother-in-law's on fixed income. My wife doesn't work, so it's primarily the financial burden is on me. I'm doing the best I can. But, we went out and we got the correct size oak trees, the canopy trees, and also the shade trees. Unfortunately, however I planted them, they went into shock and they died, so they didn't last very long. We spent probably almost $3,000 on getting those trees installed just to have them go into shock and die. Like I said, things have been very, very tough financially. So time had passed since we were able to rectify that issue. Mr. Cortez got back in contact with us to follow up. My wife and him have been going back through the email. Like I said, I'm behind the wheel for most of the day, so I can't, I'm not on my phone a lot. But we had since gotten the trees in, and the reason why I put 0 on the fine is just, I just can't afford it. And this is a house that all of my children, my family live in. If that fine gets imposed, I don't know what I'm gonna do. We're already hanging on by a shoestring. And we've done our absolute best between me, my wife, and, I work long hours. When I'm not over the road, I'm home, I'm doing everything I can. As you saw in the picture, I got the lawn back up. The trees might have been gone, but I did my best to make that exterior look nice, to make sure the grass was there and everything I could do, so.
Thank you. Does anyone else have any questions?
Question for staff. So when you guys gave the notices for the removal of trees without, is this a removal without permit issue, or is this a,
They didn't replace.
Let me take a look back here what the original notice
When I
stated.
did find out that we needed a permit, I did immediately come in and pay for those permits.
Okay.
Yes, we did cite them for needing a permit.
Permit for removal of trees, and then code says you have to have X amount of tree coverage on your,
Right.
Correct.
so nothing in that says required height, does it?
There are, obviously, the code does specify the height, although when they're coming in for the permit, it's not typically code that's speaking with them, it's our permit department staff, so I can't speak to what they are specifically telling people about, size and type and location and that sort of thing.
And on the permit, it doesn't specify, so there's no actual document that is given to the property owner to notify them that when the tree is cut down, they must replace it with a certain height of tree and certain type of tree.
Yeah, the permit doesn't specify the height or necessarily the specific type. It just says generally, either 2 canopy and 1 understory or whatever the specific requirement is.
Now, when the violation was sent out, was that information on the violation of the height?
No.
Okay. So basically, unless I'm misunderstanding this, there's no way that the property owner would know that they're required to have a tree of a certain height installed, unless they come down here and ask.
Yeah, typically the permit department should be providing that information to the citizen when they're requesting it, but again, I'm not there when they're conveying that information, so I'm not sure what the permit department is telling them when they issue the tree removal permit.
Okay. That's all I have to ask. Does anyone else have questions?
I just kind of have a comment to share with the board. It seems that as I read through what Mr. Adam Andrews has to say, they certainly were working towards coming in compliance with going to a professional seminar, the Arbor Day, to look at trees, planting trees, having trees die, planting more trees. And it seems that we need to take into consideration that it appears from everything that was written, and staff can tell me whether I'm just misunderstanding it, that he was certainly working towards that goal very diligently over the 2 years. Yes?
Are you asking if they were cooperative? Yeah,
Yes.
I would say they were cooperative with code enforcement.
Well, I understand that $14,500 is a lot of money for anybody to come up out of their pocket, especially a single homeowner with raising a family and with a single income coming in. Would the board be opposed to reducing this fine to a more reasonable number that's, say about $500? I understand that they've been trying to comply, but I do feel that $14,000 is a lot of money.
I would be amicable.
You what?
Yes, ma'am.
I would be even lower, just a cursory amount of $100, just to indicate there was a problem, we fixed it, there was an issue, we gave you a little bit of money to fix it.
I have one question. Is this the Sky Ridge HOA that the property is in? And usually, from my understanding, the HOAs have their own rules regarding the tree size. It has to be a certain diameter, a certain height, and you're familiar with that?
No, sir, so we weren't in direct contact with the HOA. From my understanding, it was directly from Mr. Cortez when we were initially made aware that they had pursued not only me, but 60 other homes in the residence.
So usually what happens with the HOAs on trees is it's more from the declarant side or the developer who says, as part of the covenants, each lot will be X amount of wide, be no more than, or no less than so many square feet. Each tree or each lot shall have 2 trees with a minimum caliper of 2 inches. And that's for more of the building of the development itself. It's not necessarily stating that each lot should have 3 trees that are 30 foot tall, that are 10 inches in caliper or something like that. It's more of just each lot should have this many trees on it.
But
not size.
the HOA has its own architectural control committee.
Right, which the city doesn't enforce or have anything to do.
They don't enforce it, that's right. But didn't they reach out to you regarding the trees?
No, sir. The first contact I had was from Mr. Cortez.
It's unusual. Okay. That's all I have.
Okay. Would anybody like to make a motion?
I'll go ahead and make the motion. In the case CEB C2402-0018, I move that the existing fine be reduced to $100 with the stipulation that the reduced fine will be paid to the city of Clermont on or before, and I would say 30 days rather than 90. Failure to pay the total reduced fine will result in the fine reverting to its original amount of $73,050.
But before there's a second, I believe you got the case number wrong. Would you amend your motion to C2304-0040
Yes.
for that? Okay. That's fine.
And that would be on June 23rd. Would be 30 days.
And I second that.
Okay. Yeah. He has to make an amendment?
I think he adopted a friendly amendment, if you all agree, to change the case
Yes.
number to the correct number.
Okay. Does everybody agree to it?
Yes.
Yes.
And yes for me too. You're welcome.
$100.
Okay, moving on to item 5. This is case number C2504-0037, Advenir at Clermont LLC, 600 River Birch. This is a repeat violation, and the code sections here are going to be section 125-522, general development conditions, specifically building permit required, and sections 108.1 and 108.4 of the stop work order. General development conditions, building permits required. And for these two, I just kind of wanted to make it clear to the board that I'm not saying that the respondent was in violation of these two sections, but these sections are included when code enforcement places a stop work order on the premise for someone doing work without a permit. Screenshot from GIS showing the property's location. A violation notice was sent out on March 29th, 2025. That was also hand-delivered to the leasing office staff. That was received on May 2nd, 2025. The compliance date was immediate. A hearing notice was also hand-delivered at that same time. And again, that was signed for on May 2nd. The result of the inspection as of today is that the property is not in compliance. This is a copy of the repeat violation notice and notice of hearing, followed by the USPS tracking indicating that it was delivered. This is the Code Enforcement Board's previous finding of facts. This is an affidavit of hand delivery, just indicating that I hand delivered the notices to the staff there at the leasing office, specifically Beth Rodriguez, the community manager. The following slides were taken from the Advenir at Clermont website, and by using the website, I was able to basically take a virtual tour of their location to see what the premise looked like prior to the alterations that they had been performing. So this is the exterior of the building. Moving inward and looking to the right of the leasing office, you can see kind of the staff area. This is a view to the left, more of the leasing office, a gym type center in the back left there. Moving on, more photos. Their fitness center. This will be one of the areas that had some alterations performed to it. Kind of looking over to the right, you can see an office in the back. There's the office. This is another area where some alterations were done. The following photographs were taken by me during my site visits. Again, this is the front of the building. The leasing office, it's kind of taped up at the moment. Moving behind that, that was the fitness center. They had closed it in, gotten rid of some of the glazing there, some light electrical work. This is the other side of the fitness center. This is my stop work order that I placed. This is a view kind of from the corner there, trying to show a little bit more of the area in question. A spool of Romex and the office area that had been enclosed. And that's the other side of the enclosed office. The staff recommendation to the Code Enforcement Board is to find the respondent in violation of Section 125-522, General Development Conditions, and further order that a daily fine in the amount of $500 be imposed, starting from 4/29/25, the date of my initial inspection, and continuing every day until the property comes into compliance. I have nothing further. I believe a representative for the property owner is present.
Hello, I'm Ashley Bastrop, I'm the community manager at Clermont. So my construction team didn't realize that when they were putting up the walls, that they were putting up and closing off the gym walls, because we're in the process of redoing the clubhouse, that it would be needing a permit. They are working on getting the permits. I know they're waiting for the building stuff to come through, so the permits are in process. As for the electrical work, they just literally moved the plug from down below to up top, so they didn't think that they needed a permit. So we are not doing any work. My clubhouse is a disaster, but that's okay, we'll get through it. So $500 a day, I don't know, I'd have to talk to my owners and see what they say. Maybe once we come in compliant, we can come back and get a reduction. But I know that they're working on the permits, and unfortunately, it just takes time in getting everything that we need to get together to get the permits. I know I can tell you who the construction company is. It's Legacy Builders, and they're finalizing the drawings to submit for the permit. And those should be submitted at any time. Unfortunately, when he did stop us, the stop work order, it does take time to get those permits. It's not something that can happen like the next day. When you need drawings.
My question is, you had a construction company do work on renovating your space, and they didn't know they needed a building permit?
No, not
Okay.
what they were doing, unfortunately. I'm not in charge of that part. I'm just the representative.
Yes, and I have a question. This is a community building, is that correct?
It's an apartment community. It's the clubhouse.
Yes, so that's a community building.
Yes, ma'am.
Okay, therefore, the board would have to vote on renovations and approve renovations for a certain amount of money, is that correct?
No, this is an apartment complex,
No,
not
it's an
an,
apartment.
not like a condo HOA.
Oh, okay, I'm
Yeah.
just asking,
Yeah, I'm like,
because
I
I
was
need to be
confused.
sure.
I was like, huh?
Yeah, because I'm just wondering who approved,
My owners.
that would be the
approved.
the owners
reason
of
why
the,
they were closing off those windows was because the designer didn't like the windows. So it didn't go with what her plan was. The room that he showed off to the left where you could see that was an office, that's actually gonna be a package room, so it's gonna be a Luxor room where the residents can have their packages delivered to the office inside the Luxor room. So it's no longer gonna be an office.
well,
And again, for staff. This is a repeat violation, which means they were told they needed a building permit, and they continue to work without a building permit.
No, not
Okay,
exactly.
all right.
What this means is that there was a previous code enforcement case. Specifically, there was a case about a year ago on the property for something like 40 to 50 outside AC units that
Yes,
were
yes.
installed without a permit.
Yes.
And so that was what that case was about, and so they needed a permit for that. And now that they need a permit for this, we're citing them again under the same building permit required section.
From my understanding, so I wasn't the community manager then, but from my understanding, we purchased the property with those air conditioners that were installed by the old company. So they were not aware that they were installed without, because we don't install our air conditioners. We have a company that does it because they get the permits and everything for that very reason. But they purchased the property with those air conditioners like that. They just inherited poor management from prior. So in reality, it really wasn't our fault. And I did pull up the paperwork where they gave them till September 13th, 2024 to come into compliance, and they did. And they were in compliance in the time that they asked them to be in compliance for. And we had to get permits and a company to come out there and repair all the air conditioners that they found that weren't in compliance. But like I said, I wasn't the manager, I was told by what's on paper.
I have a question for staff. In regards to the modifications that were done, putting in a wall where there wasn't a wall before, just getting a permit, will that solve the problem of, let's say, the fire code as far as egress? And would that wall have to be removed prior to any further modifications?
So right now, what staff has cited them for and what we would require for them to come into compliance is that the necessary permits be issued. Not necessarily that they be finaled, although they would have to be, or that would result in another code enforcement case potentially down, in the future.
Down the road.
But right now, what we need from them is to have the permits be issued.
And we're working on it.
Have you submitted the permits yet, or you're still waiting to do that?
I believe they're still waiting to do that. From what I was told, they're just waiting on the drawing, because I spoke to one of my construction people earlier, and he said they're finalizing the drawings to submit for the permits. So I think that there should be submitted by this week for the permits.
Okay. Okay.
I mean, they just told us on May 3rd, and this is not even like 19 days later.
Okay.
So,
And just so the board is aware, no permit has been submitted yet. There's nothing in the review process at this time.
I see. Okay.
So,
Would the board be agreeable to give the plaintiff 30 days to get these permits? And if the permits are not submitted and approved within 30 days, that the $500 a day fine will continue and accrue?
Couple things about that. Under Chapter 162.09, if you find that a repeat violation has occurred, the fine, you impose the fine, it begins to run from the date the repeat violation is observed. So that's why in the recommendation it's from April 29th, 2025. It's up to you and your discretion of what your order is and what you decide if they are in violation or whatnot. But the statute, if it's a repeat violation of a board's prior order, anticipates that the fine begin to run from the date the repeat violation is observed.
Until they come into compliance?
Correct.
Okay, I'm agreeable to that.
So would this be a number 6 then, instead of number 5?
It'd be number 6 with the caveat that you state the amount of the fine as it begins to run from April 29th, 2025 is the request of staff. And the date of the original order was, looks like July 20, it looks like 29th, 2024.
you're gonna fine $500 a day from July 29th, 2024, so we get come in compliance?
No, ma'am, staff's request, I'm sorry. No, ma'am, staff's request is that if they find a repeat violation, that the fines run from April 29th, 2025. So the date is observed.
Okay.
So as far as the notices go, what's listed on there, obviously the notices were hand-delivered to the leasing office staff along with the stop work order. That was the same day, but the notices are also sent to the property owner at whatever mailing address they have provided through the Lake County property appraisers. So that second date is showing when the property owner or their agent, wherever that mailing address is, actually signed for it.
Okay.
But of course, I wanted to let the leasing office staff know as quickly as possible.
Any other questions?
No.
May I get a motion?
Sure. So I'll make a motion, based on the testimony and evidence presented in case 2401-036. I move to find that the respondent is violation of the City of Clermont's Code of Ordinance as listed in the notice of violation filed in matter. I move that these violations constitute a reoccurring violation, that I have considered the gravity of the violation, any actions by the violator to correct the violation, and any previous violations by the violator. I move to order the respondent correct the violations on or before July 14th, 2025, and refrain from repeating the violations thereafter. If the respondent does not comply with this order, a fine of $500 per day will be imposed for each violation that is repeated after July 14th, 2025. The fine shall accrue from the date of the violation is repeated until the date is corrected or observed and documented by the code enforcement inspector. The respondent is further ordered to contact the code enforcement inspector to arrange a reinspection of the property to verify compliance with this order.
Couple things. Just
Yes,
'cause
sir.
I want, the case number you read off was the original case number from the case from July of 2024.
My apologies. I'd like to correct the case number to case number C2504037.
00.
0037.
And then my question is, in your motion, did you state that the violation constitutes a repeat violation, or were you just imposing a new order, giving them a compliance date?
This would be a new order.
Okay, so if it's a new order.
Should that be number 5 then?
If it's a new order, no, you're fine, if that's your motion. But the amount of the fine, you said $500, that's for a repeat violation. It's $250 a day if you're giving them an original violation.
Understood.
So, if you do want to amend that, probably best to restate the motion.
I would like to continue at $500.
Okay, so is your motion, you're finding them in repeat violation?
Yes, it's based on staff's, you're stating this was a repeat violation, correct?
Right, okay, I was just making, okay, wanted to clarify. So his motion was that he is finding them in repeat violation and imposing a $500 a day fine if the violation continues past the date you provided, and I don't recall what it was.
July
July
14th.
14th.
July 14th.
Yes.
Thank you.
Okay. Now that we have that cleared out, do I have a second?
I second.
Very good. All in favor?
Aye.
Aye.
Aye. Motion passed.
Okay, we're going to skip item 6 and move on to item 7, which is case number C2503-0001, Kevin Henshaw at 1620 5th Street. The code sections cited are City Code Section 1853, prohibited items, conditions, or actions constituting nuisances, Section 1854, creation or maintenance of a nuisance by property owner declared unlawful. Section 1855, notice to abate. Section 123-100, required. Section 3028, special refuse problems. And Section 308.1 of the International Property Maintenance Code, accumulation of rubbish or garbage. This is a screenshot from GIS showing the property's location. This is a case summary. This complaint came via in-house complaint from the sanitation chief, Chief Carnes. The violation notice was sent out on March 4th, 2025, was received on May 1st, 2025, compliance date March 16th, 2025, hearing notice April 18th, 2025, date received May 1st, 2025. The notices were posted together on the property on May 1st. Results of the inspection as of today is that the property is not in compliance. This is a copy of the violation notice. Notice of hearing and the affidavit of posting for the violation hearing notice on the property. This is a photo of the property taken by the Google Street View. That was as of July 2019. This is a photo of the property, Google Street View, as of March 2025. This is a photograph taken by me on site. Photograph of the tree debris that the sanitation chief was making the complaint about. Picture taken 3/6/25, 3/17, 3/17. The posted notices as of 5/1/25. The staff recommendation to the Code Enforcement Board is to find the respondent in violations of sections stated, to assess a fine of $150 a day per day for every day the property remains in violation after June 19th, 2025. Further order that the respondent shall apply for a tree removal permit pursuant to section 123-100 and 123-101. The number of trees removed must be specified in the permit to the extent known. In the event the exact number of trees removed is unable to be determined, the permit may indicate a reasonable percentage of trees removed, which staff estimates to be approximately 45%. I have nothing further, and I believe the respondent is here.
Was he sworn in?
He's an attorney, doesn't have to be.
Hopefully that's not because we don't tell the truth, because I'm sure you're trying. Thank you. My name is Jimmy Crawford. I'm an attorney with Crawford, Monica, and Holt, and I do represent Mr. Henshaw in this case. And I have a couple of questions for Mr. Cortez, if I would like to. I'd like to look at the violation notice and talk about it individually real quick.
Go back here. Okay.
Thank you very much. The first one is code section 1853, which is depositing, leaving, or permitting to remain on public property, accumulation of trash, litter, debris, garbage bottles. That is still in violation on the property today?
No, sir.
Okay, so that one is not before this board for, to be found in violation, right?
No, sir. I would like them to be found in violation of that section.
Because, even though it's cleared now, but you still want it found in violation?
Yes, sir. That's correct.
And why, is that normal for your department? I mean, from what I've been listening to and my experience over the last 30 years, it's a bit unusual.
I would say it's case by case.
Okay. Would you mind putting back up the PowerPoint you had that showed the timing of the case, when the notices were mailed and that?
Okay.
The violation notice was mailed, I suppose, on March 4th, and it was received on May 1st?
The date received for the notices would have been May 1st via a posting of the notices on the property.
And that's 2 weeks, no, that's 6 weeks after the compliance date. So he didn't even get a notice of the violation until 6 weeks after you
The notices were sent and not signed for. The respondent was emailed about the violations. I would have to look to get the date on that, though.
Is an emailed violation notice in compliance with Chapter 162 and your procedures for notifying people of violations?
That wouldn't be following statute 162, but just to try to inform the respondent in any way possible.
Right. Are you aware that the respondent resides most of the time in Canada or much of the time in Canada?
No, sir.
So that violation is clear, but you want to find them in violation. What would be the reasonable time given by this board to clear that then?
To come into compliance, you're asking?
Yes.
Well, the property, that specific code is already in compliance.
Okay. So if the board finds us in violation and gives us a reasonable time to comply, what would that reasonable time be?
Well, we would ask the board to find them in violation and to come into compliance by a specific date. That would be for all of the violations to include obtaining a tree removal permit.
Okay. But you're asking this board to find code, the first one, code section 18-53, in violation, even though you testified that it's in compliance today.
That's correct.
Okay. Let's move to the next one. 1854, creation or maintenance of a nuisance. Is that the same set of facts that gave rise to 1853, or is that, what is the nuisance alleged in this case?
The nuisance would be listed in section 1853, subsection 2, refuse.
Okay, so that's the same violation that you said is currently clear.
A different code section.
Right. Same set of facts on the ground, same debris or whatever.
Sure, yes.
Okay, let's just move to the next one. City Code 18-55, notice to abate. This one is interesting. I'm not gonna read the whole thing, but it basically says if there's a report of a condition of 1853, the debris accumulation on the property, after due consideration, the city manager shall direct the city clerk to notify in writing the owner, given 10 days from that date to have it removed from their property. And if not done, the city would have such work performed, which the city would claim and enforce a lien against such real property. Do you know if that was followed in this case?
Well, for the notice to abate section, I mean, I would refer to perhaps the code enforcement manager or legal as to how the city exactly goes about that. But in this particular case, up to this point, that has not been done.
Okay. Even though section 1855 says within 10 days of notice of the accumulation of debris, the city manager shall direct the city clerk to send the letter. As far as you know, no letter was sent.
That's correct.
Let's look at the next one, 123-100, which is the tree removal violation. It says that a tree may not be removed without first securing a permit from the city unless it's exempted by other provisions of the code. I'm gonna need to either come over there or have you show I got part of the code to talk about. Okay. Can you?
Will you have a copy for the code board?
I do. I have 3 copies, but I don't have a copy for everybody. I didn't.
Okay. Do you want to give those to the code enforcement board so they can see what we're referencing?
I thought we could put it on the
Yep.
overhead.
Yeah, can you put it on the Elmo?
Let's see.
Gosh, if you don't mind, if it wouldn't take but a minute. I'm sorry, I'm used to the overhead working. Here you go. Just give me 5 of each, and then with the 3 I've got, that'll work. Sorry about that.
So, let me, this is case from sanitation, right?
Correct.
Okay. Evie Wallace, City of Clermont. So I'm going to just give a little summary here. The reason why Officer Cortez wants to put that, the first violation as a violation and not take it away is because it was complaint-driven, and that was a violation. So we want to, obviously approve that violation, because there was a violation. We're not saying that the property the property is still non-compliant because of the permit that was never required, that was never acquired.
The tree removal.
Correct. So we put the abatement sections to enforce it if the debris was not removed. Yes, the debris was removed. That is not the issue right now. But everything was on the notice, so we have to present to the board all the sections. We can't just amend the notice. You know, we're gonna just present all the sections, but we will always say, this section, you know, is in compliance. However, the whole property is non-compliant. And that's why,
So the tree removal permit.
correct,
Okay.
correct.
How could he have possibly complied by the compliance date since it was 6 weeks before he received the notice?
I mean, he received it, right? It was posted, yeah. So the property was posted, it wasn't delivered by, 162, but it was posted. Again, this was a complaint received from sanitation. They do this on a daily basis. They always provide addresses at, you know, for bulk pickup. We create code cases. There could be 5 sections that we put on the notice, and maybe half of those sections come into compliance. We still have to provide the due process and send the notice because the property is not in compliance. And that's why we went in front to the board. But the abatement part is non-existent right now because the debris is gone. So that is correct. However, the tree removal permit was never applied for. I know Mr. Henshaw has been speaking with the planning department, I believe, about lot sizes and removal of trees. He just never came in to acquire a tree removal permit, which is, you know, is something I think that everybody should know if they're looking at, you know, clearing land.
Sure, but unless the tree was exempted from some of the provisions.
Right, and they could probably give you a little bit more information on that. You still want me to go ahead and provide the copies, sir, to them?
I do,
Sure,
please.
okay.
I need to show those. I'm sorry.
Would council like us to take a brief recess while she's doing that?
If the board wants to, I'm happy to. If not, I can stand here and tell the dad joke.
It's up
I'm
to
good
y'all.
with a recess. Is anybody else?
It's up-
Need a bathroom break or anything?
Okay.
Well, by way of preparation, the code provisions that I'm gonna show you say that there is an exemption from the tree permit requirement for any non-preferred tree, and there's a list of those. There's an exemption for any tree in a power or utility easement, and there's an exemption for any tree that is not 6 inches diameter, about that, 4.5 feet off the ground, DBH, they call that diameter breast height, right here. So any tree that you cut that's not preferred, that's in an easement, or is less than 6 inches, 4.5 feet off the ground in diameter is exempt. You don't need a permit for that.
Yes, but it's fairly obvious by the debris, the size of those trees were far beyond 4 feet.
Well, I'm not sure what was obvious from it. We're gonna try to drill down to the bottom of it right now.
See, I think you took my copy, sir.
There's 2 big stuff.
Is this 2 of them here?
Yeah, I think so.
Okay.
Paper management is not my best
Okay,
skill.
all right.
You got the.
Yes, sir, thank you.
Council, which table is this in the code?
I'm not sure mine, here, take these copies for now. The way Muni code prints for me, sometimes it cuts off something that it really needs.
Now, these are listed trees,
Yes, ma'am.
non-preferred trees, which means, if I'm not mistaken, these trees can be cut down without a permit?
I would defer to your staff, but yes, ma'am, that's what it
staff, can you let me know if that's correct or not?
I'm sorry, can you repeat the question?
The question is, the list that I have before me, before the board, is non-preferred trees. Are these a list of trees that can be cut down without a permit?
I would need to defer to legal.
Give me a couple minutes.
Did you guys get copies of those two papers yet?
So, for the record, I believe the chart that he's handed you is from section 123-49, non-preferred trees, in the code, and it just, says what it says.
So,
I'm sorry, was
no, my question is this. I see you bring this list before us, and I understand that, and I respect that. But what I don't understand is what you're trying to prove. These trees were cut down without a permit, and you're saying that there are trees that can be cut down without a permit. That's all established. But the trees that were cut down, we have no proof of what kind of trees they are.
That's a very good point, because it's the city's job to prove their case.
Well, that's impossible since the trees were already cut down and removed.
Well, it's not impossible. I mean, we have an owner here who can testify, and I can ask the code enforcement officer if he identified any species of the trees that were cut down.
Is the owner a certified arborist that knows what types of trees he cut down?
Absolutely, no, he's
Okay.
not a certified arborist.
Okay, then, so
Okay.
how would we know what was cut down?
There is three distinct trees.
Oh, you can't do that, Kevin. You can come up and give your name and speak to peace, but the trees that were cut down that were oversized were ear trees. The property was infested with ear trees. The 2019 picture may show it, here, this. Well, gosh dang it, I don't have enough copies again. This is an aerial of sorry, an aerial of the lot in question. And I'm not asking you to be arborists. Oh, I do have five of those. By anecdotal comment, I was a forester for 11 years before I went back to law school, so I did take dendrology and identify the trees. And there are people that can identify them by the stumps. I don't think the city has anyone that can do that, and I have not tried to identify each of them by stump.
I have a question.
Yes, ma'am.
Why would the city come to this property and inspect what kind of trees they are if the trees are there? The only reason why the city would come to inspect it to see what type of tree it is to go by this list of trees, which you say is an air tree,
Yes, ma'am.
is that the city has to be notified that the trees are going to be removed, and then this code enforcement staff will come and inspect a tree and let you know whether or not you need a permit or not.
If the code said that, then yes, that would have to be the procedure, but it doesn't. It simply says these trees are exempt from the tree cutting chapter,
And it also says you need a permit to cut down trees. So,
except for these.
yeah, but you can't prove that you had those trees. You didn't notify the city that you,
Respectfully, I don't have to prove that. The city has to prove that we cut down trees that required a permit otherwise to be removed.
yes, and they've done that. You haven't proved that they weren't the trees that didn't need to be permitted.
Yes, ma'am. And I'll defer to your lawyer and the prosecuting lawyer, but that's not my burden.
I see an oak tree in there. That's what I see.
Where-
It's up on the screen there,
Oh,
too,
okay.
sir, if you.
Top big limb. That's an oak tree. Then you've got oak brush on top,
And
right from what I'm.
how top limb, I wish I had a
I'm sure there probably were other trees in there that were in this undesirable list, but at this point, you can't discern what is what without, now that all of it has been removed. I think we still need to move through this process here, so that there's still more to deal with on this case.
Okay, more beyond the tree cutting, because code enforcement has said everything else is in compliance. I thought we were down.
Well, I mean, you ready? City of Clermont only says you can put out 3 yards of yard waste per week for bulk pickup.
Okay.
Any tree work that is done by an outside party, actually the vendor is responsible for removing all of their debris, and you can't put it out there on the curb for the city to remove. You're stating that the owner lives in Canada, so did the owner do all of this work himself, or did he contract this work out?
When did you get Mr. Henshaw?
I mean, that's the point we're getting at here. I mean,
Sure. Name,
We
and
can
address for
we
the
can
record.
go back on the email chain that was sent to me.
mhm.
And my neighbor actually cut the year tree down, which the stump is still there, so if they wanna go see all that debris that came from that day is from an arborist company that cut it down.
Sir?
Stop, name and address for the record.
Yes, can you please give your name and address?
Hinshaw, 1625 Street.
And were you sworn, Kevin? in the
Yes.
beginning?
And that address is in what, is that in Canada or the United States?
Right behind us, here.
Is this your residence here?
Pardon?
Is this your residence here in Florida?
My family's.
Okay.
I don't live, but my parents live there. Like, I live right next door.
Gotcha.
So you don't live in Canada?
I do half the year there, half the year here. So I take care of my grandma and grandpa through the winter and bring them down here, and then I go back and forth.
Okay.
But I just want to, if the email chain shows that all that material was done by an arborist company, which my neighbor asked me if he could run up my side, put it there, and they removed it. They removed day 1, and it was gone, and then day 2, they put more up there, and they never did. And in the email chain, you'll see it has the name of the arborist company that did it, it has the neighbor's address and everything, and we removed it the next day. They're just tied in the arborist company that cut down the neighbor's tree. That is right in the corner of 3 lots. Yes.
So, Mr. Henshaw, did you place or caused to be placed that debris where it is?
No, and my neighbor will come here if he needs to, but none of that material is from me. None of that.
Yeah, but it's on your property,
Yes, because I allowed them to use it to be able to remove.
and you're
it.
responsible. Since you allowed it, you're responsible for it.
Okay, but none of that was from my property.
But code enforcement is showing pictures of trees being removed.
Pardon?
Code enforcement has shown pictures of an area being cleared out and then a pile of debris there, so,
Yes, what I did is I got rid of all the overgrown shrubbery that was there.
Mhm.
I kept all the giant trees, you can see every
Yes.
single one of them, huge mountains. And I'm actually in the middle of the city to do a lot, but to build a house there, so there will be a permit to clear. But during the hurricane, which we have photos of ones that landed on my neighbors on the power lines that we cut down as well, and left all the debris there for me to deal with. And the ones that fell on my neighbor's house, which we have photos of those.
Yeah, I do, yes, yeah.
Now, this picture was taken March 4th, 2025?
Yeah. But that's not hurricane stuff, that was my neighbor.
Yeah,
just got
because you
rid of it.
mentioned hurricane, and I'm looking at the date, and that doesn't correspond.
I know, well, I'm talking about the other photos.
This was an ear tree, and why, who cut it down and why?
My neighbor, it's on their property, you can go
It's
see
not
this.
on your property?
No, it's not on my property.
but that's like 10 trees there. That's not just one ear tree.
I can.
I'm just saying, I'm looking at a picture here.
Biggest tree you've ever seen, it hung over all the tile lines.
It's, I saw the stump.
It's massive. I mean, if anybody would like to go over there after this and take a look, I have more than enough to put measuring tape on there and show you.
That's not our responsibility.
Okay, well, how do I prove it then?
You don't, it's all right. Just for the record, because if we need to appeal this, I've got to ask Mr. Cortez a couple more questions.
Sure.
Mr. Cortez, are you an arborist, or you have special education or experience in identifying trees?
No, sir.
Have you identified the species of any of the trees that were cut off of this property?
Board member Mr. Fracasso stated, I believe I saw, an oak in there, possibly some other types of canopies.
In this photo,
Yes, sir.
which my client just testified was an ear tree cut off of his neighbor's property and deposited here. Okay. Do you have any information regarding the diameter of any preferred tree that might have been cut on the property?
Can you ask that again? Can you restate it?
Let's see if I probably did a very poor job of that, I'm sorry. Can you testify that any of the preferred trees that may have been cut, which would be oaks or anything not on the non-preferred list, were over 6 inches diameter at 4.5 feet off the ground?
I believe that to be the case. Yes, sir.
How do you believe that to be the case?
Based on my visual observation of the trees that are next to my truck in the photograph on the slide here.
Okay, of the trees that are piled up or the trees that are standing?
Of the trees that are piled up next to my vehicle, sir.
Right, which we've had testimony that that's an ear tree. So I was asking about preferred trees, if you have any evidence of any, and I think they were most all ear trees, so let's just use that as colloquialism. Any non-ear tree that was cut that was over 6 inches diameter.
I'm not sure what an ear tree looks like, sir, but I believe that in that pile there you have some preferred trees that have been cut down.
Okay, could you maybe point to them? That's not gonna work up on the big screen.
Yeah. I mean,
Do you see the dark center wood and the heartwood on the ends of the cuts?
which one, sir?
All of them that I'm looking at, that you can see the ends have an area of white sapwood and then darker heartwood in the middle.
I'm going to talk for Officer Cortez. Again, just to make it, summarize this came through sanitation because of the bulk of the nature of the severity of this being a safety issue. If you go down Fifth Street, that's actual curve, and one of the pictures show a partial log on the street. So that could be a safety concern. Once we get a complaint, whether it's a resident or a department, we're going to respond. We are not certified arborists. Clearly, that is, from my training experience, definitely it exceeds the measurements of, and you agree, sir, thank you. So that's why we did the abatement sections. We don't know for certain, is it an oak, is it not an oak, is it preferred, is it not preferred? But we always like to put, if there's an abatement, we're gonna put the permit required should you go ahead and submit the application, call us, contact us. A lot of people don't like to contact us and say, we just, went ahead and submitted a development plan for lot clearing. Perfect. We haven't heard anything. We haven't heard anything. Development plan sometimes is what we almost look like as a permit per se. So we went ahead and did the permit required and the abatement sections. Yes, it all got removed. We're not saying that it's non-compliant, but we want to definitely every section we want it to be approved that there was a violation of all those sections.
So the tree removal permit, you're saying is not non-compliant now?
We don't know if these were preferred or not, just based on our training experience because of the size of the trunks and also it causing a safety issue. To me, it looks like it might have been preferred tree. No one contacted us to say, absolutely, these were not preferred trees. If we had some type of communication, maybe this wouldn't even go as far as, in front of the code board because all the debris did get removed. But we do, now that we're here today, we actually, we're going to say 100%, that is not there. Safety issue is non-existent, but we want to approve all the sections because those sections and the violation notice to be recorded.
Even though the compliance date was again 6 weeks before he received the notice? So if he complied, he signed for the notice May 1st or it was posted. Received. If on May 5th he was in compliance, would you still want a finding of a violation?
It has to be recorded. Once it's written down and you as an attorney understand, once a complaint and it's being moved forward, it has to be recorded, and it will be recorded that it has come in compliance. That is not the issue here. The only issue here that we need to discuss is the fact that there was no tree permit. This could be very easily fixed if the property owner just gets permit for the trees that were cut down, and I think this would be all settled.
It would be our position that the city cannot prove a violation because they don't know what kind of trees were cut. And that is the burden. Not only do you have to prove that there's a violation, but you have to, not you, the city, has to prove that the owner caused the violation or allowed it to continue. We had testimony that Duke cut and piled trees after the hurricane, and this ear tree that fell off his neighbor's property was cut and piled there by his neighbor. The city hasn't proven any violation in this. I understand that's frustrating to you guys, and the code maybe should be changed to say, if you want an exemption, you come in and apply for the exemption. That would have solved all this. But that's our position.
Well, staff has shown pictures of area cleared
Yes.
with piles of debris out front, which would lead to the conclusion that work was done without a permit. And this is not the first time that Mr. Henshaw's been here for doing work without a permit. So, my opinion is he continues to do this continues these violations in the city without regard of code.
If the work didn't require a permit, then he didn't violate it.
He didn't go to find out or notify us that.
The code doesn't require that. It simply says those trees are exempt.
No, the code says that you have to get a permit to remove any tree.
And then it says that.
Further down, yes, so
the
the process should have been then gone to the city to go, I'm applying for a permit to remove a tree, this tree, that tree. Pretty simple. Most of the time, somebody's moving one tree, but obviously if you're clear cutting an entire lot, I would think that you would do a little more due diligence to figure out what's there, what's desirable, what do I want to keep, what's my end game, instead of let's pile 20 yards of tree debris out on the curb for clearing a lot for a potential lot split that he's trying to do.
Well, that's one tree. That's been the testimony, unrebutted by anybody. And
I have,
I'll tell you it's an ear tree.
If it's permitted, I'd like to ask some questions of Mr. Cortez.
yes, before you do that, could you please bring up the first picture you showed of the property before any trees were removed?
Yes. That was a Google Street View photo from July of 2019.
That's an oak tree right next to the sable palm.
Can I proceed with questioning?
Yes.
Okay. Mr. Cortez, do you know if more than one tree was removed from the lot?
Yes.
How do you know that?
Just based on my assessment of the tree debris that was out there.
Did you see stumps on the lot?
Yes.
Approximately how many stumps have you seen?
At least probably a handful, I would say.
How many, is a handful more or less than 10?
I would probably say probably 10.
Okay. Do you have an estimate of the percentage of trees that were cleared from this lot?
If I had to put an estimation, I would say 45%.
Okay, thank you. That's the questions I have at this time.
Then I just have one follow-up, Mr. Cortez, and then I'm gonna try to leave this alone. You counted, you saw stumps on the property. Were you walking on the property at that time?
No, sir.
How did you see the stumps?
From the road.
Okay. And the pile of debris, that's the one picture that you have of the piles of debris?
No, sir. I have more, but in this specific PowerPoint, I believe there's only 2. 1, 2, 2.
I have a question of council. You referred to one of the trees that was removed as an ear tree.
Yes, sir.
And you stated that you are not an arborist and you could not identify an ear tree if it was planted next to you, that's correct?
No, that was Mr. Cortez, I think. I absolutely know what an ear tree looks like, both trunk-wise and tree-wise, but I'm not an expert and I'm not testifying.
Yeah, and for-
Okay, counsel,
I'm trying to get to a practical solution.
is your client an arborist and expert as to species of trees?
He hasn't,
I'm just wondering how we got this ear tree into this whole mix.
anybody who is, well, maybe not. An ear tree is a very identifiable tree.
Then who identified it?
I'm sorry,
Who identified it?
Mr. Henshaw, as he was clearing.
He's just shaking his head no.
Could you please come up and just repeat what you said into the microphone?
We're talking about two things. We're talking about that tree that was on your neighbor's property, and we're talking about.
Yeah, I was just trying to be a good neighbor to let him use that. He's an older man, and he has no room to get through the machines. I did on the side of my house, so I let the arborist company do that. In the email chain, if you can find it, there is a picture of the card of the lady. I can call her and get that information from you guys if you want, and they are the ones who made that cut. All the other stuff that I cleaned up, I had to kind of get through just shrubbish and nothing huge. I left all the giant trees. The oaks are still there. There's 4 stumps still there that have regrown the ear tree material. That you can see physically. Have somebody go downtown, give them permission, go check out the stumps and show that they were ear trees. They are halfway regrown. We walked it the other day. It's all right there. And the stuff that Duke has up there, I need to find that information from Duke and find out, because they just left everything there for me to deal with. It's still sitting down there at the bottom of the hill. So there's nothing, none of this stuff was done by me. It's literally, I cleaned up enough to get all my geotechs in there, engineers, everybody to get in there. We just cleared all the shrubs around the trees. We did not remove any big trees. The ones that are down are from the hurricane, and they were ear trees, and they fell over, and I'm more than happy to have them come up and walk the whole property with me. I want to have a solution, and I want to walk it with them. Nobody wants to cooperate. It's just fines and this and that, like, let's all walk it. He's been trying to get a hold of the city for like 2 months now. We just finally said that Thursday we're gonna do it. It's crazy to me that somebody call me and talk to me. I'm more than happy to walk down and walk through the whole scenario. I'm not trying to hide anything, I'm not trying to do anything. I'm trying to do all the right stuff.
Well, I think the right thing would be to get the permit for the tree removal, and if you could state what trees were there.
I didn't remove any trees.
Well, ear trees you.
Board,
The ones that fell over, the 2 that fell in the hurricane, and the rest of the stuff was all shrubbish around.
if I may,
I got rid of one palm that was right at the front, but it was only like this high.
if I may.
All the other trees are there.
The staff recommendation, yes, there would be a fine assessed if you found them in violation and you agreed with the staff recommendation, but staff's goal is not to find the respondent. The staff's goal is to have the respondent apply for and obtain a tree removal permit, the price of which doesn't change based on the amount removed, and to my last check, it was $25 for a tree removal permit. So that's the staff's recommendation. I have nothing further at this time.
Madam Chair, if I may, Mr. Henshaw's willing to let the staff go out and look at it and try to decide. If they do that and they still say we need a tree removal permit, that these are not exempt trees, then we'll apply for the permit. But if a site visit, maybe even with an arborist, shows that the trees were not preferred trees, or they were not, if they were preferred of the DBH required to have a permit, then there's no reason to apply for a permit. And we're willing to do that, go take 30 days and go with staff out to the site and see what the pronouncement is. That might, because if we're found in violation tonight, I'm just going to appeal and it's going to be a big old mess over a tempest in a teapot. And I don't want to do that. So we would request either a 30-day postponement or an order that says staff goes out with us, and if they determine
So, well, if there's nothing further and no further questions for staff or the respondent, I have a few things to talk to you about before you make a motion. But I don't want to start chatting and then restart all the hearing. So if you want to close the public hearing, that's what I'm asking before I make some remarks to you all.
Yes, I'm okay with that.
I'm good, I have no other comments.
Okay. A couple things. The first, they talked about the burden. So you do need to know that under the code, under 162, the city does have the burden to establish that a violation occurred by the greater weight of the evidence. So what you have in many cases, well, maybe not in many cases here, but what you have here is you have conflicting testimony between staff and the respondent. And you all make the credibility determination about that. But your decision has to be based on competent, substantial evidence that you heard. So if you find a violation, it has to be because you determined that the greater weight of evidence established that a violation existed. The one proposal that if you do enter an order to direct them to go out within 30 days and determine whether or not a tree permit is necessary and then have them apply for one. That might be appealing, but at the same time, before you do that, the first thing you have to do is find them in violation. So if your real desire is for them to go out and try to work it out and see if a permit's required, then perhaps the first suggestion would be better. But you have extensive testimony both from the city and from the respondent to make a determination, but it's up to you and you weigh the evidence. But it has to be based on competent, substantial evidence.
So just to make sure I understand you correctly, if we move forward with having the city go out to make, within 30 days, inspection, then we have to,
If that's what you wanted, to have them go out and meet and then come back, that sounds more like a continuance. That's not an order, because you're here to determine
Okay.
whether or not a violation was committed or not.
okay. Well, what say?
I mean, I think at the end of the day, staff did prove a violation was committed.
Anyone else?
If the person in violation here obtains a permit for $25, would this take care of the issue?
So what you could do is if you as a board agree that a violation has been committed, you give them an amount of time to come into compliance. No fines begin to accrue until that time
After that
expires.
date.
The amount of the fine is totally within your discretion, other than it can't be more than $250 a day. It can be $1 a day. It can be whatever you all determine to be appropriate.
And if they come in compliance before the said date, then they wouldn't have to pay anything other than just the permits.
Whatever the administrative amounts are to pay for the permit.
Okay.
The only issue there is the ear tree, which does not require a permit. But we have not established who identified that tree as being an ear tree that was removed.
Well, there was testimony from staff that they saw an oak tree. There was testimony
Yeah.
from the respondent. I'm not talking about the respondent's lawyer. He was very accurate when he says he's not testifying, and he wasn't. He was making an argument. But the respondent himself did testify there was an ear tree.
But there was no expert arborist that's identified that tree. That's only
Yeah,
what
and
the owner
so
said.
The public hearings, you can ask him to reopen it if you want. But you had testimony from staff who also testified they're not arborists.
Right.
And you had testimony from Mr. Henshaw.
Madam Chair, one sentence maybe? I can help, because if these ear trees have stump sprouted, like they do, and like Mr. Henshaw said, but there's 50 apps on your phone that will identify it as what it is. So if we have
Just to the extent that public is reopened, staff would object to the extent that the trees have been mostly cleared from the property, and therefore I don't think that we would be able to identify which trees were cleared. That would be our position on that.
Okay. Do I have a motion?
Do we have a recommendation from staff?
I think it's on your screen. Right?
Yes, sir. Yes, there is a staff recommendation.
I mean, okay.
The staff recommendation, sir, would be to find the respondent in violation of section stated, to assess a fine of $150 per day for every day the property remains in violation after June 19, 2025. Further order that the respondent apply for and obtain a tree removal permit, essentially is what that's stating.
Okay. So if they get the permits before June 19th, this will be...
The property would be in compliance if they applied for and obtained a tree removal permit.
And there would be no fine assessment until after June 19th.
There would only be a fine assessed if they failed to apply for and obtain the tree removal permit prior to the date that staff is recommending, or whatever the board recommended in this case, if you found them in violation.
Okay.
Madam Chair, can I ask one question of the staff?
Yes.
I can't recall from the testimony, but if, for the board's benefit, if they believed that there were no preferred trees in the pictures that they saw, and is a tree permit required under the code for non-preferred trees under 123-9?
For non-preferred trees, a tree removal permit is not required for the removal of non-preferred trees.
That's what I'm getting at.
So to me, this basically comes down to the fact that we, as a city, which has the burden of proof, we're gonna have to go and inspect the property of the trees that were cut down, as the property owner stated that the stumps are already starting to sprout new growth.
Does staff have an arborist?
I believe Kurt Henshaw is an arborist.
I think there's a problem here because the owner says that that ear tree was not on his property. It was on a neighbor's property?
But we're concerned about the trees that were cut down on his property, not
Right.
the neighbor's property.
Right.
We're not concerned about the neighbor's property. We're only concentrated on this property, trees that were removed from this property. That's all we're concerned about at this time. So I'm gonna make a suggestion, since it is the city's burden to prove that these were not preferred trees. I recommend that we have our staff go out and inspect the trees that were cut down, the stumps, to see whether or not they were preferred trees or non-preferred trees. Does anybody else have anything else to say?
I just want to clarify that a little bit. Staff doesn't have the burden to prove they're non-preferred trees. They have
Okay.
the burden to establish by greater weight of evidence that a violation occurred.
Okay. So then they would have to go to see if there was a violation by trees that have been cut down that were non-preferred, that were preferred trees.
No, what he's saying is staff has proved that
Yes.
a violation has occurred because they removed trees without a permit. That's staff's burden of proof. Is that correct, what I'm hearing?
It's staff's burden to prove that a violation of the code of ordinances, or in this case, the land development regulations, was committed.
Okay, understood.
All right.
And if there's conflicting testimony on an issue, you all have to make a credibility finding on your own, decide who you believe. There was testimony on both sides. So you all get paid the big bucks to make credibility determinations.
As volunteers.
Yes, ma'am. Yeah, I was being sarcastic. Yes, ma'am.
Yes, as volunteers. I want that to be
Yes.
clear.
All right, I'd like to go ahead and make a motion then.
Yes, please.
Based on the testimony and evidence presented in case C2503-001, I move to find the respondent as violation of City of Clermont's Code of Ordinance as listed in the notice of the violation filed in this matter, that I have considered the gravity of the violation, any actions by the violator to correct the violation, and any previous violations by the violator. I move to order that the respondent correct the violation on or before July 3rd, 2025. In order to correct the violation, the respondent shall take the remedial action as set forth in the notice of violation. If the respondent does not comply with this order, a fine of $150 a day will be imposed for each day the violation continues beyond or past July 3rd, 2025. The respondent is further ordered to contact Code Enforcement Office for compliance and to arrange inspection of the property to verify compliance with this order.
Do I have a second?
I'll second that.
All in favor?
Aye.
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 No.
Okay.
Would you like to do, why don't we do a roll call vote? So, Madam Clerk, will you please call the roll?
Okay.
All right, Sylvester,
No.
Evan,
Yes.
Linda,
Yes.
Fran,
No.
and Sunny.
Yes.
Okay, so it passes 3-2.
Sorry,
Does not.
it does not pass.
Oh, it does not pass.
There, it's a 7-member board. It requires 4 votes to pass any matter, so the motion fails.
Okay.
So, that leaves you all to, the motion failed. I would like to hear from both counsel on this issue. Case hasn't been dismissed, but the motion failed. So, can we start with the city? Do you mind? Sure. That would be for your lawyer.
Right.
Until we take the 30 days and the first deal, we're not trying to get out or not getting a permit, we just don't think we need one.
So I know you were, so the motion failed,
Yes.
and it's now where we are. Typically, I would provide guidance to the board, but since both of you have counsel present, I wanted them to have the benefit of hearing from both of you.
Yes. So we ask the board to find a violation based on the testimony. Approximately 45% of the trees were removed from the property without a permit. Based on the photographs that we were shown that are in evidence, there was a variety of different types of trees that were removed from the property. So we ask that a violation be found and for the respondent to be required to apply for and obtain a tree removal permit, which specifies the amount of trees that were cleared from the property.
Okay, that was the motion which failed.
Okay.
So now it's, what would you like them to do?
I think the case should be dismissed if the motion to find us in violation failed. I would move so.
Okay.
May I speak for the
Yes, ma'am.
city? So staff would like an order with everything that was said for the section stated to be found in violation. If for whatever reason, because we cannot inspect, there's nothing there to inspect. If the pictures or whatever Mr. Henshaw submits to the permit department says a permit is not required for this, then we would put the property, the case in compliance. However, with that said, we will still like today's case to be recorded, and all sections stated that there was a violation.
When you say recorded, you're not talking about recorded in the public records of the county. You're talking about an order documented.
Correct, just for future, if there's a repeat.
All right, and.
This is a little different because we don't know if a permit is required, apparently. That's what I'm understanding at this point. So if a permit cannot be obtained, we would officially close the case out. But we are asking for all the sections today that have been presented to be approved.
And if I could respond, we would object to that, because of the due process problem of the timing of the notices, and because Mr. Henshaw testified unrebutted that he did not place any of those trees or the debris where they were cited. It was due power and it was his neighbor, and the code requires a finding that the violator caused the violation.
Well, it says responsible for. And if you rent out your property to somebody and they trash it and they commit violations, you as the owner are responsible for it even though you had nothing to do with it, right?
Perhaps.
Yeah, and Mr. Henshaw actually stated that Duke or Duke's, whoever cleaned up the trees from the hurricane, left the debris laying there. It wasn't the debris that was up at the road.
That's right, that debris is still, it's on the other side of the property. That's
Yes.
correct.
Correct, and in order, wherever the violation takes place and located, that's who we have to officially cite. That is per 162.
Okay, having heard that, the matter's still open. It's still open for you to make a motion. My recommendation to you is that you do make a motion one way or the other. You have a variety of options before you, but that it not just, if a motion fails to pass, you keep talking, and I'm not suggesting any particular motion, but the parties are here, it's been argued extensively, they've presented evidence, so they're entitled to, I think, a decision, one way or the other, even if that decision is kick the can down the road. But they need to have my advice is you need a determination of some kind. So typically under procedures, when an item fails, then you move on to the next one. Here, my suggestion is you keep discussing, you keep making a motion until a motion passes, whatever that motion may be.
Brad?
I'm just pondering how to express myself. I think there's missing information, which is why I voted no. Mr. Henshaw has indicated that he did not cut down the trees that we keep being shown the photo of. We keep being shown the photo of the trees next to the truck, which Mr. Henshaw has said are not his trees. He didn't cut them down. His neighbor cut them down, or a company that his neighbor hired cut them down. So I think that we would need to see that paperwork to say, here's the company that cut the trees down, these are the trees that cut down. The trees that were cut down on his property, he had an arborist cut that down. We haven't seen what the arborist paperwork says, what trees the arborist cut down. So I feel that we don't have all the information. And again, going back to the two photos that we keep showing, if I understood correctly, that's not what the problem is. It's not those two piles of trees. It's the permit. But everything keeps going back to, those are the trees. It's an ear tree. I don't even know what an ear tree is. It's an oak tree, it's an ear tree, it's an oak tree, but those aren't the trees that are at issue. It's the permit for the trees that aren't even on his property.
Well, no, I think the issue is if you go back and look at the other pictures staff had there, that's before that pile of debris was there, so you see stuff was cleared out, and then they have another picture going back.
Yep.
You're probably referencing
There.
this one.
Right.
Yeah, so this is, I think, the issue here is you have this.
But what is presented to us for the last 20 minutes was not this picture and that picture over and over again. It was the picture of the trees in front of the truck.
Right, because.
Which are not
because
at issue, right?
the respondent's counsel was going back that these trees seen here that were on the street were from the neighbors, and they were an undesirable tree, which is not really even the issue at point here, because the debris pile is gone. So the issue at point here is you have a street view from 2019 that shows extensive trees, and then staff has another street view from most recently that shows there is nothing there.
Can you go
Before
back?
it's-
Hold on. That one?
No, go
No.
back.
Probably referring to this one, Mr. Picasso.
That
Yeah.
That one?
That one
Okay.
right there.
Mr. Brackens, I know the rules of evidence don't strictly apply, but we're going right back into the staff's presentation again, which means.
Yeah, it's reopened. hearing's reopened.
So would Mr. Henshaw's tree cutting down company that handled this, what we're looking at here, be able to tell us what trees they took down? Mr. Crawford?
And just for the record, because I don't think I was clear, the public hearing's back open.
Okay, thank you very much. I have the card here of that tree service. I'm happy to share that. I can't enter into evidence because I'm handing out electronically, but I'm happy to share that, and we can call them, staff can call them, everybody can call and see what information they can provide.
I think the question was, can this contractor that did this work provide information, which would be your responsibility to bring the information to us, to show us what, the trees that were cut down were the air trees. That's all, I believe, what you were asking for? So that's the only thing, is since this contractor has done the job, and I'm presuming been paid for it, I'm sure that they wouldn't have an issue in just going into their computers and bringing up that bill of all the trees that were cut down. That's all we're asking for, which would state what type of trees they
We
are.
will provide whatever they have. I am not certain that they record the species and the size of every tree.
Well, see, there's the issue.
Well, again, and I don't mean to repeat myself, but that's not our burden. It is the city's burden to prove the violation. And the violation is not cutting trees. The violation is cutting trees that are not exempt under that chapter. And if they're on the non-preferred list, or they're below 6 inches DBH, they're exempt, or if they're in utility.
See, now here lies the problem, and I think this is where everyone in this room has an issue with. The problem is this: you're coming here with something that has been done, and we're going to take your word that it was done correctly. Am I
gotta stop you.
misunderstanding?
Maybe I can help by asking the city some questions. Council, and if you need, for the
Yeah.
city, I don't care which of you answer.
Sure.
If I have a non-preferred tree on my property, do I have to apply for a permit to remove it?
My understanding is that you do need to apply, you don't need to obtain a permit. You need to notify the city that you are removing the tree, but it does not require the obtaining of the permit.
Can you point to the section of the code that requires you to apply?
Well, the section of the code says in order to remove a tree, you need a permit, and unless it's an exception, so in order to show that there was an exception, you would need to indicate what type of tree you're removing, in which case you would not need to obtain the permit.
I have a question. In my neighborhood, the person had a Australian pine tree, which is a non-preferred. They called the city. The city said that you don't need a permit. So how is this recorded?
Do you have an answer?
Can you repeat the question, sir?
Okay. The question is, I'm a what they call an ARC in our neighborhood, which is the Architectural Control Committee. The owner had an Australian pine in her backyard. The company that removed the tree went to the city. The city says you don't need a permit to remove that pine tree. So now, how is that recorded by the city if she never applied for a permit?
In the scenario that you're giving, you're saying that a citizen has an exempt tree.
Correct.
They come in, they say, hey, this is what I have, I'd like a permit for removal, and then staff tells them, hey, it's not necessary.
Not necessary.
There wouldn't be like a record of that. We wouldn't issue them anything in that scenario you just gave us.
Well, that's exactly what I was just getting at here. this non-preferred tree and preferred canopy trees is, we can't determine it.
So, does counsel for either party have an objection to me quoting or just reading section 123-100 of the code? I know you've each talked about it. I just want to read it into the record.
No objection.
Okay. So this is the permit requirement under the code, section 123-100. It shall be unlawful and a violation of this division and the land development code to clear or remove a tree by any method without first securing a permit from the city, unless removal of such tree is exempted by other provision of this division or the land development code. For exemptions, see section 123-9. And I'm no longer quoting, but that's the chart.
So as a real estate developer, whenever you are clearing land, whatever it is you may be doing to improve said land, you provide a site plan with all of your trees on there, what their calipers are, and all of these important information that you need to show what you're going to clear and what's going where on the property. So if Mr. Henshaw is looking to eventually split this lot and build a house on there, he's gonna have to have a site plan that's gonna have to show which trees are what's there, what's a non-preferred tree that he would potentially remove. So it sounds like from what council here has just said that a permit probably should have been applied for removing and clearing that much land.
I just disagree with
Okay.
the legal conclusion there, but you're exactly right that if and when we're able to split the lot and pull a permit for a house, there will be a site plan and there will be a tree survey that shows. But what council just read said if it's a non-preferred tree, it's exempt from the chapter which requires you to get a permit. I don't know how to say it other than that. I know it's not a perfect system.
Oh, it's
or
not.
solution.
It's not.
But-
I think the best thing really would be, get your receipt from your clearing company that came in there and did that work.
We will try. Like
I
said,
think
don't
that's
know
really
what
probably the easiest way to just, we could always continue this until our next meeting in 2 months. You come back with some documentation from the company who did the clearing, with somebody who is a certified arborist with that company that would then say, we removed these trees, and these are non-preferred trees per city code, and I think we could just probably dismiss this thing.
Okay, we would be fine with that. When is the July meeting? I'm out a little bit. It's the 14th? Okay, that's fine. I'll be here.
I just want to ask our attorney something.
Yes, ma'am. Sorry.
So at this point, would this be a continuance to July 14th?
If that was the will of the board to continue it.
Yes, will we make a motion on that?
It
How
would
does-
have to be by motion.
How does
yes.
Okay.
staff's council, are we?
Yes, that's fine.
Okay.
Okay. May I have a motion?
All right, I'd like to make a motion to continue case C25-03-001 to be continued to the July 14th, 2025 meeting.
All right. Sounds like we got it then.
Do I hear a second?
I'll second.
All in favor?
Aye.
Aye.
All right.
Thank you. I'm sorry for the length.
Now, please be sure to have all your necessary information come the next meeting.
We will do our best, and we will be here, and then I'll ask for the record of this meeting to be incorporated so we don't have to redo it.
Okay.
Thank
All right, let's move right along to item 8, C 2501-0024, Quan Heng and Jin Wang at 240 Edgewood Drive. There's a lot of code sections that were listed here. I'm just going to briefly run through them. General development conditions, building permit required, 3041, general, unsafe conditions, protective treatment, exterior walls, stairways, decks, porches, balconies, handrails and guards, windows, skylight, and door frames, openable windows, insect screens, windows, general, unsafe conditions, interior surfaces, stairs and walking surfaces, handrails and guards, interior doors, bathrooms and toilet rooms, general, electrical system hazards, abatement of electrical system hazards associated with water exposure, installation, receptacles, and groups R2, R3, R4, and I1. And as is the case with most property maintenance codes, I'm happy to go over any one of them if you'd like, but essentially most of them are going to state, for whatever the specific thing is, that it be maintained in good working order, free from defects, safe, things like that, in good condition, maintained. Again, I can go over any single one of them if you'd like, but I know you have them in your packet, so I'm going to move right along here. Oops. Okay, this is a screenshot from GIS showing the property's location. A case summary, this was a citizen complaint from the tenant. The violation notice went out on January 27th, 2025. That was received February 3rd, 2025. The compliance date was March 13th. The hearing and violation notice was April 14th. That was received on April 18th, and the results of the inspection today is that the property is not in compliance. This is the violation notice. Again, it's quite long, but I can go through it if you'd like, but I know you have it in your packet, so I'll continue unless there's an objection. This was a list of concerns that the tenant provided to me when I arrived for my initial inspection. This is sort of like a collage showing some exterior siding issues on the house, missing cladding, holes in the structure, and that sort of thing. This is the second floor balcony and guard. I do have a video, so it's quick. I'll play it briefly here. And what the video is showing is that the guard that is designed to prevent people from falling overboard, so to speak, is not exactly functioning as intended. And then, of course, that and along with the missing pickets or spindles, it creates a large gap that you'd be able to fall through. This is a large gap underneath the door in the garage. This, invites pests, water, things like that. Door frame damage to one of the interior doors. Obviously, is not in good condition or in working order. This is the one of the bedrooms, sliding glass door. It does not open and close properly. It's not secured in place, and it does not lock. I frankly had to wrestle with it to even move it 6 inches. I couldn't even tell you what's wrong with it. I have a quick video that shows me trying to fiddle with the thing, and it doesn't operate as intended. It kind of will wobble back and forth a little bit and remains open. I think actually the tenant had to help close that when I left. Oops. This is the kitchen/dining room window. You can see in the photo to the left, it's not hanging properly. It doesn't open or close. It doesn't lock appropriately, and it lacks an insect screen, which the city of Clermont requires year-round. This is an opening in the garage. The tenants had a leak from an upstairs shower that was actually pretty significant. And upon my arrival initially, they had, I guess, cut that back in an effort to try to repair it. Let's see if I can move along here. Oh, stand by, we may have some technical difficulties. All right. So that crashed. Let's go back. Okay. Okay. All right. Okay. This is some abraded surfaces, some surface defects that are found in the garage along the upper trim there. It's just not in good condition. It's peeling and chipping away. That is a code violation. This is an interior handrail that was not properly secured and a stair nosing that was protruding upwards, and I actually tripped on that nosing coming downstairs, so it may look minor, but it got me on my way down, so I went ahead and wrote that up as a defect needing to be corrected. And this is just the handrail. It wiggles very easily in hand. It's not properly secured. Move along here. Cracked faceplate in the living room and a missing faceplate in one of the bedrooms. Electrical outlets, receptacles, things like that. They should be in good working order. They should not have cracks or openings and things like that. This is an electrical wire protruding from the wall in the garage. Obviously, it's not intended to look that way, so I went ahead and wrote that up as a defect in need of correction. This is an upstairs bathroom. And the electrical outlets in that bathroom should be GFCI protected, but I wouldn't be able to tell as they're not functioning, period. So those will need to be repaired and given the proper receptacle for being near water. GFCI helps protect the user in the case of moisture or water from shock and things like that, so that's why they're required in the bathroom. This is a lighting receptacle that was underneath of where the water leak was, and it's later on in the slides, but it basically was just getting soaked every time the tenants turned on the shower and running to that. So I wrote that up as a defect in need of correction. Electrical components should not be getting rained on unless they're designed, for moisture and water and things like that. This is a downstairs bathroom. The toilet's not functional, and I went ahead and spared the board any visuals with that, red circle there. So that's for your benefit and the people in the audience here. But you can imagine that was pretty gross. This is a video of the downstairs bathroom exhaust, and their exhaust vent does not work. So this is just a quick video showing that it does not turn on. You would be able to hear it in the video. It does not function as intended. That is a defect. It needs to be corrected. This is the downstairs and suite bathroom. The faucet had such extreme water pressure I wasn't even able to capture a video of it. It basically shot out. We have the tenants here. I'm sure they can provide additional testimony to that if you'd like, but the water pressure was pretty extreme for some reason. Broken tile near the floor there, and that HVAC supply register was hanging off the ceiling, during my visit. Obviously, we don't want that to fall on somebody's head and get split open. This is an improper trap. Typically, you have like a little P trap under your sink, and when you have that type of flex pipe, that is a code violation because it helps to. If you have an improper trap, you can have sewer gas and things like that come back up into the home. That's why the Florida Building Code prohibits that. This is a video that was provided by the tenant that was showing a water leak. And again, that water was leaking right onto that light that sat below it. This is another video. I took it. I'll just play it real quickly. It's a little bit higher quality. This was after, I guess, they actually said they tried to repair it the first time. And, as of my visit, that was not repaired. So that's a defect in need of correction. This is the downstairs bedroom. All bedrooms should have a smoke detector. This one's missing. This is the hallway. There's a bedroom up there. There should be a smoke detector outside of every bedroom. The photo's a little blurry, so I apologize for that, but there's no smoke detector there either. This was a follow-up visit after the property manager, a gentleman named Alex Chang, informed me that all of the violations had been corrected. So I went out for a second visit and found that there was still issues that had not been corrected. This is a downstairs toilet that does not function. I have a video, but unless you want to see it, I'm going to just continue on here. There's no functional smoke detector in the hallway outside of the bedrooms. The light that was exposed to water was not repaired or replaced. The garage door not repaired or replaced. This is another video. They have a dual function flushing switch. It does not function as intended. I have a video of that, but I'm just going to move along. Downstairs door frame not repaired. No smoke detector still outside of that bedroom. The staff recommendation to the Code Enforcement Board is to fine the respondent in violations of section stated, to assess a fine of $250 per day for every day the property remains in violation after May 19th, 2025. The reason for the short time frame is, for tomorrow, for the fines to start, is because the tenants are still there. They're still living with all of these defects. They're still paying their rent and things like that. And so to me, I think the appropriate recommendation is to begin the fines and have the property owner fix them if you agree that they're in violation. So I have nothing further. I do believe that the tenants are here. If they want to speak, they can come up.
Are you requesting a health and safety tag?
1 second. No.
I have a question for staff. At what point in this many code violations do you declare it an uninhabitable property? Not that I'm trying to make you move again, sorry.
With things like that, we would consult with the building official, which we have. The building official and our chief inspector, they were aware of the violations that were there. And although there are a lot of violations, of course, basically when you take it all into I guess like a total view in the building official's mind and the chief inspector's mind, and also in my opinion, I don't think that they warrant like an unsafe structure tag that would require the tenants to vacate or anything like that. I just think it's a lot of little maintenance issues that just need to be corrected.
If I may, since Mr. Cortez has been to the property, some of the violations have actually gotten worse. When the mom and pop contractors came in, and an electrical situation occurred where they were messing with an electrical box and ceiling, causing one of the 4 bedrooms in our home to no longer have electricity. No lights, no fans, no outlets work in that room. And then we also pay for 3 bathrooms.
Does anyone else have any questions? Thank you, sir.
Mr. Cortez, communications with the property owner, yes or no?
Yes.
Okay. And they seem amicable to be fixing, or I guess from tenant's perspective, they're not trying very well?
Right. You know, I've spoken with the property manager, Mr. Alex Chang, and you know, it's not fruitful. I really don't know how else to put it.
Just looking at the totality of the violations here, I don't see how they could, even in 2 months' time, to accomplish all of this. And in the meantime, those tenants are in danger. And I would think this property should be considered uninhabitable, personally.
I tend to agree that there's a lot of issues that we see with this house, especially considering some of the new information that they've provided us as well.
I also forgot to mention that since Mr. Cortez's visit, the garage,
Can you repeat what you started to say, so it's recorded?
since Mr. Cortez's visit, the garage ceiling, that section was replaced above the fridge, but against the rolling garage door, the entire ceiling has fallen, about 3 sections, the sheetrock, and the insulation as well. It looks like previous water damage, but nothing that I can, be certain about. And I do sleep above that ceiling where the sublayer fell out from. And the boards are still intact, the structural integrity seems stable, but that is something else that I forgot to mention regarding.
Now, was that leak that we saw in the pictures, was that repaired?
The leak above, or the leak that was depicted was repaired. Yeah, he had the walls of the shower taken out, new sheetrock or Durarock put in, and then new tile on the shower walls.
Okay.
The tub itself was not replaced because it was deemed not necessary. But he did do his due diligence to repair the leak after, I requested that the shower be repaired almost 2 weeks after I moved in when I noticed it was leaking. We put it around mid-November, and after countless months, I contacted Mr. Cortez to see if we could get, something to happen because they were not doing anything. And now we're here.
Okay. Thank you.
Thank you.
Does anyone else have any questions, staff, board, before we make a motion?
I'll make a motion. I'll make a motion based on the testimony and evidence presented in case C 2501-0024. I move to find the respondent is in violation of the City of Clermont Code of Ordinances as listed in the notice of violation filed in this matter, that I have considered the gravity of the violation, and number 2, any actions by the violator to correct the violations, and number 3, any previous violations by the violator. I move to order that the respondent correct the violations on or before July 14th, 2025. In order to correct the violations, the respondent shall take the remedial action to set forth in the notice of violation, or if different, list the specific remedial actions to be taken. If the respondent does not comply with this order, a fine of $250 per day for every day that the property remains in violation after May 19th, 2025. The respondent is further ordered to contact code enforcement office for compliance and to arrange an inspection of the property to verify compliance with this order.
Before there's a second, I just had one clarification question. In the first part of your motion, you said to come into compliance by, I believe, a date in July, but in the back, at the end part, you said if the violation continues past May 19th. So just to clarify, do you want them to come into compliance by May 19th or the July date?
Excuse me, the July date.
So that would be July 14th.
It would be July 14th.
Okay. Do I hear a second?
Second.
All in favor?
Aye.
Aye. Motion passed.
Okay. This is going to be item 9, case number C2408-0009, Fairfield Homes, Inc. at 99 Sunnyside Drive. The code sections cited are general development conditions, 3024, weeds, protective treatment, accessory structures, exterior walls, windows, skylight, and door frames, interior doors, interior surfaces, stairs and walking surfaces, mechanical equipment and appliances, and general of the International Property Maintenance Code. Again, you have these in your packet. I'm happy to go over them if you'd like. If not, I'm just going to continue forward here. This is a screenshot from GIS showing the property's location. This is a case summary. This was brought to code enforcement via citizen complaint from the tenant. A courtesy notice was sent out August 12th of 2024. A violation notice was sent out March 10th of 2025. That was received on the 10th. The property the notices were posted on the property. The compliance date was April 10th, 2025. The hearing notice was April 15th, 2025. The date that one was received was May 1st. Actually, correction, the violation notice was hand-delivered to the respondent. The result of the property is that it's not in compliance as of today. This is a violation notice. This is an affidavit of hand delivery. Okay. Notice of hearing, affidavit of posting. Some additional information on this case. This case began on August 7th, 2024, after the tenant, Robin Sickles, reported numerous issues with both the interior and the exterior of her unit. She stated the property was in poor condition and that the landlord had failed to address the problems despite repeated requests. Ms. Sickles also noted that the unit is HUD regulated and that a HUD inspection in January 2024 had identified numerous issues. She explained she had received an eviction notice in mid-September due to non-payment, which she attributed to the landlord's failure to make the necessary repairs. An inspection was conducted shortly after receiving the complaint, and I compiled a list of violations. Move along there. Multiple HUD inspections were performed and found numerous violations, many of which were overlapping with the violations that I found during my inspection. The tenant was eventually evicted, but the underlying violations remain. This is a copy of an inspection report from a Lake County HUD inspector from August 9th of 2023, outlining some of the issues that they had observed. This is a follow-up inspection on January 31st, 2024, from a HUD inspector outlining violations that they had observed. Another report from a HUD inspector dated July 22nd, 2024, with violations that they had observed. This is the exterior of the property taken on 8/8/24. Some overgrowth in the back. A fence that was installed without a permit and was not installed correctly. It relied on very fine rope or twine to basically hold it up. This is some wood rot on the exterior cladding of the home near the front door at the base of the stairs near the landing. This is like a masonry block wall that's located in the backyard that has some obvious signs of failure. This is the primary. This is the front door. There's a large gap underneath. Again, this is something that can contribute to pests and moisture intrusion. This is a photo taken of one of the windows that does not lock or secure properly. This is a photograph that was taken of their appliance room, and this door, basically, you have to shoulder it open because it scrapes against the bottom of the ground. And I don't have a video of that, so I apologize, but that was me once I was able to kind of get it partially open during my visit. This was a picture, again, taken on 8/8/24, showing the hallway where the bedrooms are located, and there's moisture damage and an obvious hole from what was an air handler issue located up above. This was a picture of the water heater. The water heater had some defects. It didn't have a temperature pressure relief pipe, which is the little kind of nozzle thing that you see on the right side of the screen. That's actually a fairly serious issue. If the water heater were to fail, if it were to build up too much pressure, it was getting too hot, it would blow out very violently, and if you're standing near that, you will get severely burned. So code requires that in the event of something like that be discharged, outside or to the ground. It just kind of depends. There's some options there, but it can't just be at, waist or chest level for somebody. That's just dangerous. In the back, there was some issue with the electrical sheathing. It doesn't exactly cover the electrical conductors that are going into the wall. It kind of stops short. It can be a little hard to tell, but that's kind of what you're seeing there. This is an improper trap, like I discussed in the last case. This sort of improper flex pipe arrangement contributes to sewer gases escaping and coming into the home, and obviously that's an issue. We don't want that for our tenants. A picture taken on 3/10/25 showing the block wall. Picture taken 3/10 of the window, the gap underneath the door, the state of the hallway where that return is, the bathroom at the time of my visit. The property was posted on 5/1/25. And the staff recommendation to the Code Enforcement Board is to fine the respondent in violations of section stated, to assess a fine of $250 per day for every day the property remains in violation after June 1st, 2025. And I believe both the respondent and the complainant/tenant are here. I have nothing further.
Do you have someone here to speak on behalf? Could you say that a little louder, please? I didn't hear you.
Is the microphone on? Okay. Sorry, sir. If you could make every effort to speak up, just so
Tip
we
it
have
up
a
just a
recording.
little. Thank you.
He's gonna try to work on the mic. There.
Yeah, well, I rented this apartment to Miss Nichols. She's been here for about 2 years. Everything was fine until I went up on the rent, and then she ceiling, and, you know, if you don't replace the filter, which is she's responsible for the filters, if you don't replace the filters, then, you know, you get debris inside and clog the line that goes out, and, you know, water stop coming the next morning. I went and addressed the situation, and we got into a big fight, and her, you know, arguing and stuff. You know, she retaliated, calling me city of Clermont, and she was fine, everything was fine at the house, you know, the stuff that you know, he shows you as far as the trap, I didn't know that was that was a code violation, I replaced it, I repaired the thing for the hot water heat, all of that stuff is repaired. He came and took pictures of it, he saw that everything was done mostly. The only problem that we have right now is the wall in the back, because he requires me to come in and get a permit. I get a contractor, and I've been, you know, asking a lot of people, a lot of contractors that I know, and they charge me a lot of money. Right now, the place is vacant, it's been vacant since January, and, you know, I'm just waiting for a good price to start working on the wall, but everything else, mostly everything else is finished.
So you say that that apartment is vacant now?
Yeah, it's been vacant since she
Okay.
left.
Okay. Does any,
I remodeled the whole bathroom, took the whole, everything. He got pictures of all the work that was being done. So all of that stuff is, the only problem, as I said, we have right now is that wall in the back, which, you know, required, I mean, I got an estimate for $10,000 just for that, you know, wall, so I'm still trying to get estimate, still trying to find somebody to get a permit.
So you stated that Mr. Cortez had been back out to see some of these repairs.
Yes, he did.
Mr. Cortez?
So I did do another site visit, and a few of the issues had been repaired, but as of my last inspection, there's still an issue with the overgrowth. The block wall is obviously still in a state of disrepair, needs a permit. The front door still has some issues. The window near the egress door has some issues. There's some interior surfaces, the hallway, that's still an issue. And then the guest bathroom was basically under remodel at the time of my visit, so that's still an issue. But some of the issues were corrected, but a full inspection still needs to be done to ensure that everything is in compliance. So those are still some of the outstanding issues as of my last inspection.
Gotcha.
All that stuff in the back, that overgrown, the sickler, she wanted privacy, so she had she was responsible for the backyard of the growth, and she wanted the backyard because she was complaining that the neighbors behind, trash was coming over onto her property, so she wanted like a, you know, it's like, she just wanted like trees and bushes and, you know, I don't have a picture of what it looked like when she was there. She planted a whole lot of stuff and do a whole lot of nursery and, you know, so it was like a whole, and I let her do it because, you know, I want her to feel comfortable. You know, that's your home, you know, just make, you know, comfortable. If you like it like that, then hey, you know, what am I?
Well, I mean, doesn't seem like you were making the house very comfortable either when Mr. Cortez shows 3 years of violations from HUD that that you get as, you know, that subsidizes the tenant's rent. And it looked like some of those same issues had been year after year. You know, a globe over a light fixture in a bedroom was on there 3 different times.
Light fixture.
The light fixture, the globe, the lens that goes over top of a light fixture. It was on the HUD report on 3 different times that I saw as he quickly went through there. So, you know.
But she probably changed the bulb and put it back because.
It was before she was in there. It was from 2022.
Yeah, but before they could pass it, before she moved in, they did an inspection and everything was.
It wasn't though, because he just showed a report that showed that there were issues that were required for you to repair.
They wouldn't have let her move in if it wasn't passed, if it didn't pass inspection.
Okay. I'm not familiar with the procedure on HUD, on how they deal with residential, but I can tell you right now, seeing the list of things that HUD has put on this property, I wouldn't want to rent from you. I would never rent from you.
sir, how long do you think it's going to take you to get into compliance?
Well, as I said, the only thing that's left right now, the bathroom is partially finished. As I
But my question was, how long do you think it's going to take you to become compliant?
Maybe another 30 days,
How long?
maybe 30 days.
30 days?
I mean, to get the permit, but I don't know how long the contractors might take to get the walls finished, because everything else is in compliance.
If I may, just to clarify, with the permit, in this case, we would only be asking that the permit be issued, so the contractor would have some time, but I just want to clarify that as of my last inspection, the wall was not the only issue.
The fence was still held up by the ropes?
The fence had been removed. That was one of the things that had been done by the
Has been
respondent.
done.
Yeah.
Personally, I didn't put the fence up. She had problems with the neighbors, and they put the fence up. So I had nothing to do with the fence.
Yeah. Well, that's not the issue. The issue is that it was there in violation.
You're representing the property owner, so it's your responsibility as the property owner to keep your property in compliance. It's not your tenant's responsibility.
Now, I have a question for the staff, just to be clear. You want the property, now what violation does he need to, is that the permit that you're looking for within 30 days? Because I want to make sure I understand this correctly, since there's so many violations. I want to understand exactly how we're proceeding forward.
Of course. So, as of my last inspection, some of the issues that I still observed was an issue with overgrowth, the block wall itself, and the permit that would go along with it for the repairs. The front door weather stripping, that gap that you saw, that's still an issue. The window is still an issue for the respondent. Interior surfaces, that's still an issue, and then the guest bathroom needs to be completed. Like I said, it was under a remodel essentially as of my last inspection, so there are still some issues that are outstanding that they all need to be incorporated in whatever time frame, that the board feels is appropriate.
Okay, so we need to, all these issues that you mentioned need to be in compliance before a certain date. Okay. Do you understand that, sir? Okay. Yes.
I was the tenant there.
Sir, can you get,
Speak of my experience living there. It was after Mr. Woodward, after he's done. Is he gone?
he's offering you the podium.
Okay, thank you. Hi, my name is Rhonda Sickles. I was a tenant for a little over 2 years. I first became a tenant due to, under Section 8. I was given an emergency voucher due to chronic illness. And I moved in, I believe it was June 2022. And the first year, I didn't rock the boat. There were, it did pass inspection, but he had probably 5 or 6 things he needed to complete within the 30 days. Those things were not completed, unfortunately, because the inspector, she abruptly left, and no one came back to finish with the final inspections. So, I was happy to have a home, but under the circumstances, I just kept my mouth shut. When things got really bad, I finally found my voice. For example, there were major holes in the glass
issue was, there was a soft spot at the front door, and for a year, that spot kept getting softer, only to discover that he hid from HUD, as he told me and he told the caseworker that the closet where I parked my car, that was not allowed, like we couldn't go in. He had a big sign that says do not enter, only because he was covering a huge hole in the floor in which me and my son could have fell through. And so when I called him on it, he bullied me, and he told me that if I didn't like it, I could leave. Of course, I'm on a fixed income, so I don't have the luxury of just finding a new place. And HUD gave him 7 days because that was considered urgent. Anything that's not urgent is 30 days. It took him over 4 weeks. And I took pictures every single day, and I gave it to Mr. Cortez of the bulliness that I was living when I was renting from him. If I spoke up, if I asked for him to repair things, which were not favors, he would just, he left, I think I gave him the text message. He said to me, I don't work for you, and I don't work with you, and I'll finish it when I finish it. And then my response was, I'm gonna put your money in escrow. And then that's when things took a strong left. And then they got worse when he submitted 2 leases to HUD, one with my signature on it and one without. And when since he mentioned going up on the rent, it wasn't an issue going up on the rent. It was an issue with him trying to commit fraud by submitting 2 leases, one with my name on it and one without. And it was Nicole Yarman, the director of HUD Housing. She caught it and made him resubmit it. And then that's when he came to me and said, oh, I'm going up on the rent. It was 1 year after I was there. I think it was $250. And prior to that, the 10 things that he was supposed to finish, they were never done. So that's when I said, well, when are you gonna finish this? And so things didn't get really heated until I found out like what kind of character I was dealing with. And then the last point I'm trying to make is the day before Milton, that hurricane we had, the ceiling was leaking, and in the ceiling is where you put the filters. So that wasn't the case. The case was that the AC was not cleaned out for a while, and that's where the water was just pouring down. I called Woody around 8 o'clock that night, and he said he was going to have someone come out. No one came out, but before he hung up, he told us to turn the AC off. Me and my minor child slept in that house, and it was 89 degrees. He never showed up. He randomly showed up the next day, no forewarning. I'll be there at 2 o'clock, I'll be there at 10, nothing. He just showed up. And I was outside because it was just cooler out there as opposed to in my home. And he showed up, and the neighbor said, oh, are you here to fix the AC? And I've never seen a man talk to a woman so abruptly, so nasty. He cursed her out so badly. And so I said to him, could you just please come inside and fix the AC? So everyone in the neighborhood knew that, based on what he said to them, that I didn't own the property, that I didn't have anything. He just belittled me to the core in front of the neighbors. The neighbor said, this is were about to have a major hurricane that was coming that day. And he just lost it on the neighbor. And she said, well, this is Robin's place. And he said, she doesn't own shit. She doesn't have shit. And that's when I was just, I felt this thing. Like, just because I'm on HUD doesn't mean that it doesn't define who I am. You know, I didn't ask to get sick. I didn't ask not to be able to work in the medical field like I was working for 14 years. My situation changed. And I just feel like this man preys on women who have less, who can't fight him financially. And yes, I did hold my rent because I was paying for things that he should have been paying for. My son went without Spectrum for probably 5 months because he was told, and it was in the contract, that he was supposed to clean all the debris. No, didn't do it. So I had to take that rent and pay a few people to go up in the trees and cut all the debris from the lines so Spectrum can come out and service us. And the director did come out, he did an inspection, and he said, okay, we can start coming out servicing you now. It was, I had to do that. He was asked to do it by HUD. He didn't do it. So, moment I brought in code enforcement, he retaliated by having me evicted. So, we had a court hearing, and he didn't even show up for the court hearing. So it was about me not paying rent. He didn't even make it an issue. He was a no-show. So that, I'm saying all to say this. He was just verbally abusive. And like I said, I didn't have the luxury of moving at that time. But I was blessed enough that HUD realized they were dealing with it, they stopped paying him. When they kept asking him to make repairs, and he just took his time. It just seemed like he just takes his time and thumbs his nose up at the system. And if you don't have the finances to fight him, you're a victim. And that's why I'm here. And he was verbally abusive to my son. My son heard him talking to me very derogatory. My 15-year-old son says, you cannot talk to my mom that way. And he said to my son, I don't give a shit. And that's another reason why I'm here, because he has no boundaries. None. So, I just poured myself out. That's how I feel.
Thank you. Thank you very much. So, bottom line is, you have violations, and these violations have to be corrected. The staff says that these violations, all the violations that you mentioned that are still not
In compliance?
yes, still
Okay.
not in compliance, has to be done by June 1st.
That's correct. That's my staff recommendation.
Yes. Do you understand that these violations,
That may be right. I'm not sure. I'm not sure how many days it is exactly.
So
for the wall, you could try to obtain an issued permit for the repairs. You also could apply for a demo permit to demo the wall. Those are the two options.
And you're talking about that, cement wall?
Yes, ma'am, yeah, in the back.
It's in the back.
Concrete block, yeah.
That looks to me like to be a retaining wall.
Yes?
So in the event that this collapse, all that dirt and stuff behind it is just gonna just fall down if anybody happens to be there, or they park their car there, or whatever.
Well, you've got a tree in there too.
Well,
That's,
pretty big tree.
yeah.
Sir, you do have quite a bit of violations here, and they are serious. They're not minor things. It's not, like, I understand with the window and stuff like that, but this here is serious. And they do have to be attended to.
I'd like to go ahead and make a motion.
Please?
Based on the testimony and evidence presented in case number C2408-009, I have moved to find the respondent is in violation of the City of Clermont's Code of Ordinances as listed in the notice of violation filed in this matter, that I have considered the gravity of the violation, any actions by the violator to correct the violation, and any previous violations by the violator. I move to order that the respondent correct the violations on or before June 1st, 2025. In order to correct these violations, the respondent shall take the remedial action as set forth in the notice of violation. If the respondent does not comply with this order, a fine of $250 per day will be imposed each day the violation continues past June 1st, 2025. The respondent is further ordered to contact Code Enforcement Office for compliance and to arrange an inspection of the property to verify compliance with this order.
Second.
All in favor?
Aye.
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 Okay, moving on to item 10, case number C2503-0020, Vet Development LLC. This is a vacant property located on 7th Street. The code sections cited are section 3028, special refuse problems, 12341, maintenance and pruning, section 1853, prohibited items, conditions, or actions constituting nuisances, 54, creation of or maintenance of a nuisance by property owner declared unlawful, 1855, notice to abate, 1856, failure to comply, lien. A screenshot from GIS showing the property's location. This is the case summary. This was an in-house complaint from the code enforcement manager, Evie Wallace. A courtesy notice was sent out on March 26th. The compliance date for that was April 13th. The violation notice was sent out April 15th. That was posted on the property. The compliance date was April 25th. The hearing notice was sent out April 28th. That was also posted on the property on the 28th. The result of the inspection today is that the property is not in compliance. This is a copy of the courtesy notice that was sent out. This is a copy of the violation notice that went out afterwards. Notice of hearing and affidavit of posting. A picture of the property taken 3/25/25, 4/15. This is the notice of violation being posted on the property on 4/15. Notice of violation and hearing notice posted on 4/28. And then a picture from today. There's a parcel that's not owned by Vet Development to the right, which is undergoing some permitted construction. The staff recommendation to the Code Enforcement Board is to find the respondent in violations of sections stated. Also, to issue an order authorizing the city to begin the abatement process. Furthermore, authorize the recording of any and all costs incurred by the city as a result of the abatement to the county clerk in the form of a lien. I have nothing further.
Okay, so just before you all start, is the respondent present? Anybody? Okay, before you all start your deliberation process, the city passed a new ordinance in 2024 with the nuisance abatement process in it, and then you all became the guardians of that. So there's not a recommended motion in here with respect to just the nuisances. So my recommendation is to follow the staff's recommendation in the form of a motion.
I would like to make a motion to accept the staff recommendation on case C 2503-0020 to find the respondent in violation of the section stated, also to issue an order authorizing the city to begin the abatement process. Furthermore, authorize the recording of any and all costs incurred by the city as a result of the abatement to the county clerk in the form of a lien.
Anyone second?
I'll second that.
All in favor?
Aye.
Aye.
That's it.
I have a question for council.
Yes, sir.
On case C 2501-0024, I believe that may have been worded incorrectly. Are we able to reopen that, or is that done for the evening?
Couple things. Say the case number, which item?
Item number 8, C 2501-0024.
Which part of the wording?
The way that our motion was worded. I believe it was worded backwards. It may have been flip-flopped with the way our other board member made the motion. That's why I was asking, is that something we can?
So the easy answer to that is no.
Okay, thank you.
And the reason being, we can, at a later date, we can correct any issues. I don't recall specifically what it was. I know there were several issues just with the form of motions, dates, case numbers, things like that. We'll review the minutes, and if there's any issue, next time we'll bring it back and go through that process if necessary.
Okay.
But that gives me the opportunity to say this. So each of these hearings are quasi-judicial in nature, but sometimes they come back. Sometimes they're continued. So we don't discuss them at this, like the merits. That was a procedural question, perfectly appropriate. But, you know, we don't discuss the cases. We had a lively one tonight. We're not going to talk about it here. When it comes back, that's when we talk about it.
Thank you, Counselor.
At this time, I believe the staff has something they
Yeah,
need to say.
very brief. I know it's a long night. It'll be very quick. We don't say this often enough to you guys, but we want to say thank you. Last month was April. We didn't have a meeting, but that was National Volunteer Month. So as a token of our appreciation, we have a little gift for you. But again, we want to thank you for your time and effort that you come here and spend this time to do the city's work. So again, thank you. And Evie's coming. Again, it's just a little token, but thanks. They're
For the rainy nights when we leave out of here.
yeah, this is going to be a rain dance, right? We haven't had much rain. This is what's going to bring it right here.
Thank you.
Thank you,
Yes.
thank you.
But that's all. Thanks. Thanks again.
Thank you very much.
That was so sweet, thank you.
And I thought you were gonna read us some new rules and stuff.
Training session.
I wish it could have been quicker tonight, but no.
Thank you
all.
very much.
Sure.
I know we're not going to talk about it, but I swear that attorney said, I'm not going to make a big deal about this.
Counsel?
One other question for, I guess, Ms. Ray there. Our motions of forms, is that something you can email with our next packet?
Absolutely.
Thank you.
And I'll make sure she has a copy of it, and we'll email it to you. And I will include an updated one for the nuisances.
Perfect, thank you very much.
Gold-plated.
Motion to adjourn.
Aye.
Aye.
Aye.